name, it states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading
That
on
is not my
the
name.
final jury instructions.
That is not my name, for the record.
All right,
I
the
don't
record should
recognize that
reflect,
name or-
Mr. Brooks, I'm talking. The record
I
should
don't.
reflect that at 3:23 p.m. yesterday, all of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to take one or two breaks before I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch, to have the parties provide they're not opening, their closing arguments. And then following the closing arguments, the court has the final jury instructions, which go through the closing instruction, instructions 460, 484, and all of the verdicts. And then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the verdict is received. So page 107 is not something that will be read today. As indicated yesterday, I will be selecting the alternates by random selection. We'll use the tumbler and select 3 numbers out of that, but that will be done after all of the instructions are read and the parties have an opportunity to give their closing arguments.
Your Honor, set for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought
Jury
out a
instruction
little
conference.
bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed?
Mr. Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to. I was put in the holding cell for over an hour because they said it was some paperwork that needed to be.
That is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties. So that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
I have to look through his paperwork to see if they're on here.
What holding cell are you referring to, Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those. Thank you.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in. That was on top of my folders.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
but they are also on your desk now.
I accept for value in return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over an hour?
There was no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell.
But can they have been delivered to the jail?
All right. I don't believe there's any other preliminary issues we need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right. Anything else from you, sir?
Yes, there is. Yesterday, I stressed to the court numerous times about me not understanding the proceedings, and essentially how decisions are being made on my behalf without my understanding or giving consent.
The court made various rulings yesterday. I made findings and ultimately made some determinations. I stand behind the record that was made. I'm not going to explain it further.
So a lot of those decisions were made when I was not present in the courtroom. I was in the other courtroom, correct?
That is true, sir.
Is that correct?
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
Sir, the decisions were made yesterday. I'm not revisiting them today.
They need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record. I'm still trying to understand, Your Honor, how you made a judicial determination on my behalf, which I did not give consent to, as you say, I forfeited my right to testify, which I never did. I never said I wanted to. I never said I didn't want to, but that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no. And it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that affairs can be put in order properly, and so that the people that want to come in and speak will have the opportunity to address the court.
I think
If
that's
that
a fair
pleases,
request, sir.
If that pleases.
I think that's a fair request. I thought about that and some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone. If there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf? How long do you think it will take? So that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right. So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence. Nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do. I did that.
Mr. Brooks, you may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them. And to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit
this
the opportunity?
jury is here
to be able to place into evidence.
Mr. Brooks, I'm not going to debate this further.
I'm not trying to debate. I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you made a judicial determination. You made it. I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things in the evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr.
that
Brooks,
clearly help my defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record, your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks,
I'm just seeking to understand. I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence,
the filings that I filed.
Rulings, or
I'm asking a question, Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings with this court are in the court record. That does not mean they're evidence, sir. And I told you
that's not what I'm asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
So they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with all respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr. Brooks,
may I give an offer into evidence?
I'm going to stop you once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It
We
should
are
not
now
be though,
at the
Your
jury.
Honor.
I understand your lack of consent. Your
So
objection
when would I
is
be able to
noted
put?
for the
When would
record.
I be able to put vital information into the record, which I haven't had the opportunity to do?
That opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I
I'm going to
asked
do the
before
following,
yesterday,
sir.
Your Honor.
I'm going
I
to do
asked
the
this before
following.
yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying to
of the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the
I
record
am
does
going
not.
to take
It
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you, there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum.
Well, then
courtesy.
just hold me in
You-
contempt, then, Your Honor.
You are
Hold me in
hereby
contempt because
advised
I didn't even. I'm trying to
that if
seek to
you start
understand.
talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your
in
Honor.
any way
We're not talking
interrupt
about subject matter
the
jurisdiction. We're
reading of the
talking
jury
about
instructions,
why my due process
I
has been
will
violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment,
Great.
Section
I'm
1.
taking a 5-minute break. We are
Your
in
Honor,
recess.
I don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will be
don't agree
coming
to a
as well.
estoppel. Your Honor. Estoppel? You say the word estoppel?
the jury is.
Your Honor.
What's up, y'all? Sorry, I'm just getting my camera
for the record.
situation sorted out here. Keith, thank you for those stars,
And
man.
upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it.
Are you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your oath of office.
I'm going to have to excuse the jury. Mr. Brooks, I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now you'll respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
He will
Mr.
definitely
Brooks,
interrupt.
I very expressly warned you.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you pledge to me that when this jury comes
No,
back out,
he is unable to do that.
that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in dishonor?
refuses to answer the
Have
questions.
I acted in dishonor,
I have given
Your Honor?
him an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
Well, guys and gals, great people of the community. I think we saw this coming, right? His inability to do what he's supposed to do. Courtroom decorum. Yeah, sorry guys, I had you muted. I'm having to recalibrate my little studio setup here. This guy, man, what a real gem of a human being. What gets me is it's I can't say funny because it's not funny anymore. It's just wickedly annoying. Is that he brings up points that were exhausted by the judge, and she's been incredibly clear about these things, such as the evidentiary inclusion aspect of this case. They had an entire year almost to, we'll give it this, 10 months, we'll say, of case preparation. Everything from his witness list to the professionals. They had experts in toxicology. They had experts in accident recreation that were going to be called as witnesses. None of that mattered. None of it mattered because he fired his defense team. That is funny to me now because everything he's saying is just over the top obvious that he thought he was Billy Badass, and it turns out that he's a Billy Beta, who's going to be the jailhouse bitch. And I'll just say it, man. I don't mind saying that right now. I know that I try to maintain a unbiased standpoint, but this guy deserves everything that's coming his way. And you hear his asking for a stay of jurisdiction on sentencing, as if to say that he gets to wait another year in county, right, while they're waiting to tell him where he will and will not be spending the rest of his life. So yeah, they found THC in his system. That was what the tox call it. The tox report was going to come back and tell him.
Please be seated.
He's now been removed to another courtroom.
Reflect that Mr. Brooks has been placed in the other courtroom.
He's been put in his fort
on mute so that I can make a record. I do need to confirm that the audio and visual
while the jury is coming out
equipment and system is working. I am getting a thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there.
I have a banner that's already ready to go
Mr. Brooks has the
for
headphones
this case,
on.
for this particular thing.
This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom. Once again, we are at an important stage of this proceeding where the court needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is always something that I will give him. As soon as I make my full findings, I will pause and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made
to
this
respond like a
morning
castaway
to
on an
remove
island
him
somewhere in the
is based
South
on the
Pacific.
authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he
we already know how this is going to go.
Jury instruction.
He'll be building a fort.
Phase of this trial by either objecting.
How long do you guys think it'll take? I want to see in the comments. How long do you think it'll take before he's building a fort?
Bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate.
5 minutes? Yeah. How long do you think it'll take?
That,
Courts in 30. How long is it going to take
we
before the
will
jury's removed
take
from
a
the
pause.
courtroom?
We'll recess. We'll come back in when he is set up in this courtroom. Thank you, everyone.
Jeez. This is our life right now, guys. A lot of back and forth with Darrell Brooks and his just well, you know, the beauty part is here, guys, is we've been through this. This is no shocker to us. You know, we know that this ass clown over here, where's he at? This way? Yeah, that one. We already know what he's going to be doing. So we're saying 2.5 minutes, 5 minutes for how long it'll take him to have an outburst. It's going to get him kicked out of the courtroom. We've seen it time and time again. And he's trying to be, the only time he really makes a real, I don't want to say public outburst, but the one when he really throws it at like into hyperdrive is when it's referring to the judge and how he hasn't gotten the things he's supposed to have and yada, yada, yada. I don't know if he's going to have much to say about this because all she's reading is the jury instructions. And so I'm curious if in said jury instructions, there's going to be a time when we'll be, we're going to be dealing with points or factors in the instructions for the jury that he's going to object to, which is going to be, I don't even know. I don't know I don't have a clue what some of his objections are going to be because we've seen so many. I mean, I would have said hundreds, but I'd say well into the 1,000 at this point objections. And that's not an exaggeration. I think we can all agree that he has fully showcased that he'll object to his own comments. I think he objected to some of his own questions when he was called to some of his witnesses. And it just blows my mind. They took away, if you weren't here yesterday, let me see if I can pull that up for you guys real quick. Which was it's just the fact that he this guy, man. So he asked for yeah, he here we go. I'm just gonna pull this up because it's funny. He asked for and while this is pulling up, we'll just throw in the comments when they come back in. And thank you for sharing the stream, guys. Thanks for being in here, for the comments, for the likes, for the notifications that you set up to make sure you come back in here. It's great. It's great. And it needs to happen because, like I said, we've been in this and we're winding it down. So this guy. So
Put him on top. He put him on the floor. That's his right. They're not in front of him, but it's by his own conduct that he's done that. The record should reflect Mr. Brooks is muted because he wants to continue to debate with this court about my prior rulings regarding his forfeiture.
here's what happened when they put him in the courtroom
For
yesterday.
their
I'm gonna
evidence
turn the
on his
volume down there a
behalf.
little bit just so we can talk. So this was a video from yesterday. Just want to make sure. Here, I'll put a banner up so you guys know what's going on.
I know one of the things I probably need to look at, I'm not sure if
There's
that
so
will
many
be
of
this or
these that
not,
I have to
will be
make
the
sure.
Language from the amendment, from the amended information on count.
So this is the judge doing exactly what she's going to try to accomplish today, which is,
70.
no, well, all right. Well,
No, I don't want to do that.
this is when he begins to build his. Oh. Well, we're going back in, so.
Mr. Brooks?
We're back in, so we're staying in here for now.
Are you going to act?
We'll watch some
I've already
videos.
addressed your
We'll have time.
request.
It hasn't been proven for
Building
the
a
record.
box for it.
The jury is on its way.
They're not out yet, though.
They're
So
on
I
the
want to
way.
badger you with some
I'm
bullshit that I've
not
been giving you from the jump.
Addressing these matters, sir.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in
you're
any
back
way?
Yes,
in this
you
courtroom
don't
at your request. The
stop
jury is
interrupting.
coming
I
up.
never should have
Please
been.
be respectful of their time.
I
and of this
have
process
been. They weren't
and
even
the
out
dignity
before.
of the
Because
proceedings.
They
He's
weren't
hedging
even
his
out
bets here.
before when I was trying to address what needed to be
Mr.
addressed
Brooks.
before they came out. Am I
Just
acting
attempting
in
to disrupt the
dishonor?
proceedings.
Am I acting in dishonor?
100% all the time, nonstop.
So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's
No
a
one's
tacit
going to get
agreement
30
that you don't
seconds
have to
before the
answer
jury's
questions
removed
as
from
a
the
public
courtroom.
servant,
All
right?
right, the jury.
No
is
jury's
not
out.
Mr. Brooks.
No jury's
close the
out.
door.
They didn't even make it in the room.
I was trying to
Mr.
address
Brooks,
this
they are
before they
right
came out.
outside this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out. And if you
and you're
say
making
one word when that door
you're
opens,
making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting.
Here
in
we
dishonor
go. Let's
by
give
making a
it. We
tacit
haven't even made it in the
agreement
room yet,
that
you
you
guys.
don't have to answer any questions as a public servant.
Haven't even made it in the room yet.
You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right.
contempt?
The jury cannot come in.
Are you gonna hold
All
me in
right.
contempt?
Mr. Brooks is going to be removed. We're in recess until then.
How am I
Who said-
acting in dishonor?
Who said 42 seconds? They didn't even make it in the room. So whoever bet the lowest on that one wins. Spook Max 9 said 30 seconds. Who else over here? Let me check some of these comments. Oh man. Wow. I'm sorry. I think it's hilarious because they should keep him in there the entire time. Like there is no time that he should be allowed in the courtroom at this point. Like he's done nothing but completely disrupt and distract and like take away from the court proceedings. So yeah, I think Spook Max hit it. The closest one to the mark was 30 seconds, which that was the court they hadn't even got the jury in the room yet, you guys. And we've been seeing this from the hip hop, you know, from the jump of it all. That's the business, as Darrell Brooks would say. You know, the business is they put you in timeout. So maybe while we're doing this here, we can pull up this other one of him building a fort yesterday. This is what happened when they put him in the court, when they put him in timeout yesterday, which is you know, he this is hilarious. So he's taking some boxes that all of this, the evidence that he doesn't have.
76 count. Just want to make. It says near Frank Park, so it is in there. But that was just one question.
Yeah, it's like a Lincoln Lego blocks. Oh man.
So, state have any requests as it relates to the jury instructions?
I'm just going through each one. I'm on page 50.
They were going over what they were going to talk about today. This was them just discussing yesterday what they were going to talk about today, what was in the jury instructions. And he couldn't handle doing that. So he proceeds to do this, to build this box fort. Man, guys, that was deadly serious. I was going to build a box fort and then do the stream from behind a box fort, but I just ran out of time to build a fort. But man, 30 seconds. You were spot on with that one. Yeah, he didn't even make it. Didn't even make it into the jury. The jury didn't even make it into the room. They just, oh man, that just blows my mind. So yeah, he's phenomenal at being a ridiculous, like antics filled,
Mr. Brooks is requesting to go back
disruptive,
to his cell.
defiant.
I'm going to deny that request.
He was requesting to go back to his jail cell. Here's the thing, and tell me what you guys think about this. Weigh in on this one. This little scene from yesterday was him doing this one the whole day. You know, like, can you guys see? Can you see? You can't see me, so I don't exist. I don't identify as a human being with a body. I'm the ghost of the defendant or the third party representation of the person who's not here. Boom. Yeah, that's not how it works. What a complete ass clown. You are right. So yeah, he requested yesterday. He just kept saying, I request to go back to the other courtroom. I want to go to the other courtroom. As if to say, like, you just have the right when you're defending yourself for multiple homicides, for mass murder. He just don't like the way it's going. So he's going to go ahead and just request to be put in a timeout courtroom where he can go ahead and play games. Like we've seen it where he's taking his shirt off. You know, he's screaming at the judge. Like that. See, go over here doing this one. Just being the biggest clown on the planet, man. Share the stream, you guys. Make sure to share it out. We have hopefully I'll be able to.
He's muted, but I can certainly hear him from this side.
He was screaming so loud from behind his fort
I can't
that
decipher what he's yelling.
okay, that he they're coming back in. So we're gonna go ahead and jump back into the back into the trial here.
I have confirmed he can hear and see as well. I would note he does have the headphones on.
He's not deaf or blind.
While in that courtroom, he just lifted them.
I'll hide behind the Bible,
as well, or at least part of them. This court has previously relied upon
You're muted, fool.
The U.S. Supreme Court case of Illinois versus Allen.
He flips out when he can't
the
disrupt
United
and yell at
States
the judge.
Supreme Court indicated it is essential to the proper administration of the criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least three constitutionally permissible ways for a trial judge to handle such a defendant, including 1, bind and gag him, thereby keeping him present; 2, cite him for contempt; or 3.
But she's doing
Take
everything
him
she can
out of the courtroom
to
until
not
he
cite him for
promises to
contempt
conduct himself
because
properly. I understand
somehow
Mr. Brooks is waving to the court. I'll address that
that'll
momentarily.
set him up for a potential
But the bottom line
mistrial
is
or
there is a
an
history
appeal.
of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him, given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions.
I think we can agree he won't be able to do
I
that.
will unmute him so that he can indicate what he would like to say to the court. You are unmuted,
Subject
sir.
matter jurisdiction.
Go
What do you guys
ahead.
think? Bets on what he's going to say.
Can y'all hear me?
We can.
Raise the
First
sound in the
of all,
courtroom a
at
bit.
9:25, I would like the record to reflect that the prosecution was making
There you go.
disparative remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful.
We don't care what you think is
For the record.
disrespectful.
And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've
Shout out
my
to
ruling
A1
as far
Media.
as anything
Thank
that
you
was
for
done
jumping
by the
in here.
prosecution. I was not in the
Appreciate you. Get the
courtroom.
shout outs and
The jury was not
tapping in
present.
with your
Whatever
crew.
happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give
Check
you
out
that
A1
opportunity.
Media, you guys.
Otherwise,
Facebook, YouTube.
I am
Twitch,
going to
and-
bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper.
Mhm.
And when you do that, pledge to this court that you will not interrupt.
What's
these
a pledge to
proceedings.
this guy?
Without
You know what I
that,
mean?
I will not bring you back into this courtroom.
I'm curious what a pledge would be to this guy. Like, what does that look like? What is? I solemnly swear to not be
Anything
an
the state wants to
asshat,
put on the record.
to respect the
I have a
court.
question, Your Honor. I don't have anything directly in response to Mr. Brooks'
There you
last
go.
statement.
All right, go ahead.
Jeez, yeah.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do
Yes,
again?
it is. We can take the witness stand camera and
Yep, he can
pull
read
it
and
out
write.
so that he has a view of the jury box as
He
well.
can hear and he can
Can't
speak.
angle it, but I can
Yeah.
do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before
Right,
we.
please do that, Madam Clerk.
And if you're in here right now, you want to become a supporter, you guys. It's a supporter / CJTV Media LLC on Facebook. Thank you so much for the stars, the contributions
It's
to
not
make
on
this
Zoom,
possible,
and
super
so
chats
the
and stickers
court
on
TV would be
YouTube.
able to fix the camera
And for
on me
that,
and not
the
on the
$4.99
screen,
membership, you guys,
so that they don't
helps
capture
future
any
planning,
pictures
keeps
and
the
they're
lights on,
directed to
keeps this guy running right here.
Same thing, obviously, with our still photographer.
All contributions today are going to go directly towards the box fort that I'm going to build for sentencing. So it'll be amazing. Okay, that's not true. But maybe some of it will.
Capturing members of the jury.
Yep, A1, they locked him in another courtroom. Well, let's not say they locked him. They
Thank you,
moved him
Your
to
Honor.
another
The
courtroom
record
where he is
shows like
shackled and has a
without
taser
the
hooked up to his
camera,
feet.
It looks
Right.
like about 90% of the jury box can now be seen. In
Katie,
the view
thank
if
you.
Mr. Brooks chooses to do
Right.
that.
And these are the arguments they'll have back and
Mr.
forth all
Brooks,
day.
I'll unmute. What is it you would like the court to address?
I object to being called Darrell Brooks.
How can you rule that I don't have the right to be present in the courtroom?
She read all
I've
of that.
answered that previously.
Yeah,
I've
she
made
read
my
it all.
findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself.
I'm an idiot.
And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
Well, I think we've had something like 17 to 20 minutes since 8:30 this morning of timeouts to make clearance for him being moved back and forth between two courtrooms. Again, you guys, thank you for setting notifications. Make sure you're aware of what's happening when it's happening. Today, just so you know how this is going to go, they are going to be doing the jury instruction there towards the end, but they are going to do I believe, and if I'm not mistaken, it goes preliminary jury instruction. They're going to go through that. Yeah, Destiny, thank you very much. Again, you guys, thanks for all the contributions to go towards my box fort that I want to build. That'll be amazing. The Darrell Brooks is going to spend life in prison box fort. But we are going to then have closing arguments. And this will be interesting because if you guys don't recall, Darrell Brooks's his opening statement, which he gave last week. Man, I wish that we had time. We only have like 2 minutes, but if we had more time, I would give you guys I'd give you that. Instead, I'll give you 20 seconds of me getting tased. How about that?
Okay, if I had a bong for my chat, you would get it. How about a bong?
Hello. It's official now. I feel like the later the night goes, the more my laugh sounds like Seth Rogen. So,
Yes! Got it! Yeah!
Good times, right? That's the early days of old CJTV, back when I was down in Portland. Anyway, the judge will be back. You guys, they had a plea option. So one of the initial pleas they gave was kind of basically saying, "Hey, Darrell Brooks, the prosecution said the plaintiff, the state, as he called the state as a witness, and one of the many things that he didn't have time to do or didn't have the opportunity to do, and the preparation of things he didn't do, he and the state that he called, of course, was denied, but." They had offered a plea, and the plea was, if I'm not mistaken, and it was hard to understand entirely how this was read out, was that they would suspend the charges for the 61 counts that he's facing. And let me give you guys again a breakdown here. He's 61 counts of recklessly endangering safety, but they would hold the 6 counts of life. So basically, what they were doing in the plea was like, all right, we'll mitigate some of the charges, but you're still going to get hit with the 6, counts of first-degree intentional homicide with life in prison. So plead guilty, don't plead guilty, whatever you want to do, we don't care. You're not going to see the light of day again. So, and again, the combination for all of these down here is over 900 years plus 6 life sentences. And that's not including bail jumping at 2 counts and battery at 2 counts, which at this point the courts have done. And I'm saying this with all due respect. And I mean that with all due respect, which is
truthfulness or untruthfulness. It's not specific instances of conduct. It's character evidence, which frankly wouldn't even come from the witness.
It is in the Geneva Convention. You can look it up. But the courts for the last entire life of Darrell Brooks have done an amazing job of allowing him to just basically ice skate his way through the guidelines of sentencing, through proper penalty for the crimes he's committed. He should have done no less than 30 years at least. He's done no more than 3 collectively between county and state prison. So between county correctional, county jail and state prison. I mean, this is ranging with everything from rape of a child. He raped a 15-year-old girl, and we know that, got her pregnant, considers her his ex-girlfriend, and then beat her up multiple times, including the night of the parade attack. He did a little over a year for that one, which was again just under the sentencing guidelines. Had she been a couple months younger, in 14, that would have been a 30-year sentence. I mean, he's been released on his own recognizance. He's been PR'd, which is released on your recognizance. He's been given $300 bail for a stack of charges that were sitting. He's had court commissioners and court judges that have just kind of let him go. So the judge at this point, I think, is tasked with leveraging the penalties that are consummate for the crimes he's committed, with no variance, with no deviation from the strictest and harshest of punishment at this point. And this isn't even about Darrell Brooks anymore. For me, I think for the sentencing, we all know he's cooked, but it needs to be seen. I think a strong hand that'll say nothing like this is ever going to be permitted. Nothing like this will ever be allowed. You're never going to be able to put on a show like this, dance through the courts like this, do what this guy's doing, and then, you know, have a window of opportunity for seeing the light of day. And, you know, really, he wouldn't make it on the outside any more than I think he'll make it on the inside. He'll be in protective custody the entire time he's in prison, because he's a child rapist, mass murderer. Sorry, but not sorry. You don't have a life expectancy when it comes to correctional facilities. They have a way of handling people like him. So that's what, you know, we have to look forward to. So the judge is burdened with everything that the defense team that got released didn't have to do, which is being involved in this case. But she also has to do her diligence, as she has been throughout the court proceedings, to make sure there's no windows left open for a plea bargain. There's no windows left open for, or not a plea bargain, sorry, for the appeal, making sure that there's been absolutely nothing done that would allow an opportunity for mistrial. And there have been multiple times that they've had to jump through these hoops where even the prosecution, in the video we watched yesterday, when Opera was cracking off and saying, "Hey, listen, I know why you're doing this. We get it." But it's the judge's call if she wants to tell him to sit down and shut up, like to be quiet. Sorry. But you haven't, is how she worded it. And we understand why you haven't done a lot of the things you've done. And, you know, we appreciate that, because he's hoping that she'll hold him in contempt. If she holds him in contempt in some way, because of his pro se status that he's in, which is self-representing as his own attorney, or the third party representation, as he would like to say, third party representation of the defendant, that potentially could open the window for a mistrial of some type. I don't know why. And I've got an attorney that I hope, if we have time, we'll bring on today, and we're going to talk a little bit about the case and get some questions answered that you guys might have, and I know some that I have. Ashley, thank you, Gene, you guys, for the stars. You guys are awesome. And Barry, where's Judge Schroeder? Well, you asked for him, so guess what, Barry?
Pardon me? That was before the
Don't get brazen with me.
There he is, right there, Barry. There's Judge Schroeder giving you the business. We've had this actually is was the plea bargain that was originally offered up by the DA, and hopefully this gives an idea of what we're talking about.
Your Honor, the offer that was dated July 5 of 2022 reads as follows: plead to counts 1 through 67 in the information. The penalty enhancers on all counts will be struck. Counts 68 to 83 will be dismissed and read in. The state will recommend 6 consecutive life sentences on counts 1 through 6. The state will recommend unspecified prison on all other counts.
I mean, anyone else, I'm sure, would say, like, that doesn't sound like much of a deal. But in his case, that should show you how confident the prosecution is. And all of us are, in the evidence we've seen and everything that we've gone through with this case, as to how incredibly cooked this guy is. Even in that, they're like, all right, we'll strike 7 counts. I think it must have been counts, whatever, 31 through 38, 31 through 37. I'm guessing it would have been the reckless endangerment, and the recklessly endangering safety, and they would have gone with the 6 counts of first-degree homicide. So now the 6 counts of hit and run involving death, or not 61 counts. Yeah, they would have. Man, that was tough to figure out. In the comments, feel free to correct me on this. But as it works out, even the 6 counts of hit and run involving death, I think those are a leveraged penalty at max of like 30 years per. So that's like 180 years just between those, you know. I think it's 12 and a half years for the 61 counts of recklessly endangering, 12 and a half years per for recklessly endangering safety. So that's 700 plus years right there. And then, of course, 6 life sentences for first-degree intentional homicide. I think where they might have, and don't hate me for saying this, they might have a little bit of a hiccup is proving that he intentionally killed. And again, don't hate me for saying this. They might have a little bit of a hiccup trying to prove that he intentionally murdered 6 people. And then but here's the thing. Even if they go to reckless homicide, I believe that's like 35 years or 30 years. I'd have to look up the sentencing guidelines for reckless homicide. Let me check that for you. In Wisconsin, it's wild. Like, yeah. And it sets, here we go. Reckless homicide sentence. Okay, so 60 years. Okay, first degree reckless homicide and a serious criminal charge to face Wisconsin. In Wisconsin, section 940.02 of the Wisconsin statute prohibits the crime, and it's punishable by up to 60 years in prison. And then a more mitigated. So here, I'll put this in the comments over here so you guys can see that. So this is what they'd be looking at with if they had a reduction in his charges from first degree intentional homicide to first degree reckless homicide. It's still 60 years up to 60 years. So, I mean, yeah, 360 years on that, and that's quick math. Drop stars for the math on that one, if nothing else, because your boy's on it. I'm telling you right now. Yeah. No, what we're seeing right here is what I got things flipped on my camera here, is the actual court. So they're not back in yet. We had Darrell Brooks building his box fort over there, but you guys want to see a quick clip, and I've showed you guys this before. This is 54 disruptions that happened in the course of one of the days here. This blows my mind. So this is just from one of the other days here, which was a quick clip. I'll show you.
I've taken the jury out at this point to admonish you that any further mumbling under your breath or not recognizing when I uphold or sustain an objection that I will take as a disrupting interruption meant to disrupt the proceedings.
Disrupting.
I'm not holding you in contempt. I'm well aware that that's one of my options. I choose not to do it for the reasons that I've stated on the record previously. All right, you can forfeit your right to be present at any point in time during this trial by your conduct under Illinois versus Allen. When it is disruptive, when it does not follow the simple rules of courtesy and decorum, I draw your attention once again to SCR Chapter 62, which has been previously provided to you, which is under the statute there. These constant mumbling and interruptions during the proceedings. I haven't made a record of them today, but I will now. Started at 9:01, then there was 5 at 9:02, 3 at 9:03, 4 at 9:04, 1 at 9:05, 2 at 9:05, 1 at 9:06, 3 at 9:08, again at 9:17, 9:27, 10:31, 1:05. There was talking over by you at 2:03, 5 interruptions at 2:14, 2:15, 2:17, at 2:19, audible muttering, 2:31, 2:33, what I would describe as inappropriate, like muttering under your breath, 2:35. At 3:06, there was a hilarious comment. At 3:11, there was what I would describe as arguing about the muttering and the irony of it all. At 3:12, there were 4 interruptions. At 3:37, more 4:09, 4:10, more mumbling. At 4:11, twice, and at 4:12, 9 different times. So I think I've made an ample record of the disruptions today. I've been abundantly patient with you.
She said 9 times at 4 o'clock. It was just it's funny because that day I was trying to keep track myself. I was like, doing a hash mark for, well, at first I was trying to keep track of objections. Not possible. I was legit just sitting there doing like, chicken scratch for objections. And it got to a point where I couldn't even get over to my notepad in time. So it just was like this page of, and it got up to something like 74 objections as I was counting on my scratch. It looked like have you guys ever seen a hurricane map or like a tornado map? Yeah, a tornado map. It's just the lines everywhere. It looked just like that. It's somewhere like a little bit longer, maybe. I don't know, maybe there's a better objection or a worse objection. Either way. Yeah, this guy. He's been doing everything he can. Yeah, he's tried COVID, he's tried everything, but it's not working. So the judge has, like she said, been abundantly patient with him. She gave him 54 outbursts that he had. That was that was just between 9:01. I think they started court that day at 9:00. And they had a lunch break that I think went a little long. They had a couple breaks in between, but I'm saying, like, you figure as like a 6-hour period, maybe 5 hours, he had 54 interruptions. I mean, do the math on that one if you want. I would, but man, after that 60-year, the 360-year sentence math that I did, I'm kind of cooked on that one. So, yeah, he's been examined. Cindy said it right. He's been examined by multiple doctors. He's not insane. He's fully competent to stand trial. He's without the ability to pull that card. They had that on there. They pulled it back, and then they found him competent to stand trial and to pretend himself, if you will. Yeah, which is really what it is. He's his own self pretender because he's acting like he knows what he's doing here. And it's ridiculous. Well, they're coming back in here, guys. Share the stream if you would, please. Pick a group in your personal, on Facebook or wherever you're at.
They were before
Share it
at
out.
9:45.
And let's.
Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room. I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury
claims he's a
will be
sovereign
brought out.
individual.
I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request,
Wilma.
I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All right, go ahead.
So are they bringing him back in? Is that what we're... So I apologize for the ocean sound in the background there. It's the pickup from the cooler, the fan on the computer here. But yeah, so he's process, so someone, or process, sovereign citizen. So the question was asked, what's this not wanting to be called by that name? He claims that he's a sovereign citizen. He doesn't adhere to the name that is Darrell Brooks that was assigned to him at birth. In all caps, which would make him a property, if you will, of the corporation of the United States. It's a whole thing. Yeah, so there's a lot more in the sovereign citizen situation, sovereign movement that you can look up. But one of those things, as it says here, is they believe they are not subject to the laws of the courts, which is wild because this entire time he's talked about his rights. But he's also claimed that he's sovereign. It's crazy. So if your rights, the subject not to the laws of the court, don't appeal to the court about the rights that you're not getting, if that were the case. But yeah. Jared Schmidt says he wrote a note saying he did not ask to be removed, and judge said, "Awesome, nobody cares." Touche, Jared Schmidt. Touche. And the jury's coming in now.
All right, for the jury.
So we'll see what happens. And again, you guys, thank you for the stars on Facebook and the super chats, super stickers over on YouTube. We are also on Rockfin, Twitch, and Twitter, Periscope, however you will. So on the platforms you see at the bottom of the screen there in the ticker. Make sure to set up notifications for the future as we move forward through the case here, and as we get down to final statements, final arguments, closing arguments, which will be today after lunch. So.
Members of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorenson with intent to kill that person, and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Kulich with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Wilhelm Hospel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial factor in producing the death. Two, as to each count, the defendant acted with intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count two, you should find the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count two. If you find the defendant guilty of count 2, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4. If you are not so satisfied, you must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty as to count 5. If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Lofgren under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21.
I'm going to go for one more minute on the poll on Facebook. Will the jury go with first-degree intentional homicide? Simple yes or no. If you're on Facebook, chime in.
Utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Mathioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3.
I open another poll on Facebook. Will Judge Darrow give the max sentence for all guilty verdicts? Again, that's something she can
21st count
she can sway on.
Information in this case charges that
Because there's a lot of them.
on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 22nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yaretsi Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Coelho under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Thank you, Anna.
The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin.
Yeah, this is the long stretch, you guys, right here.
Madison Hollingsworth, under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of information in this case charges
Darrell Brooks is down, man down.
Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Pielmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information
Good question.
in this case.
What is he
charges
raising his
that
hand for?
Darrell E. Brooks on or about
The
Sunday,
white
November
flag,
21 of 2021. on
Gary
Main
says
Street
he's
in
waving
city
the
of
white
Waukesha,
flag. He
Waukesha
says,
County, Wisconsin,
I get it.
to recklessly
I'm
endanger
cooked.
the safety of
I tried.
Julia
It failed.
Schleichow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub
Thank
F,
you very much,
and
Leah. I appreciate that.
939.63
I
sub
do
1
my
sub B
best.
of the
Do
Wisconsin
my best.
statutes.
You guys make it all
The 32nd
possible.
count of the information in
Part of
this
the community
case
here.
charges that Darrell E. Brooks, on or about Sunday, November
Thank you.
21 of 2021, on Main Street, in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a
That's a
dangerous
tough one,
weapon,
Mark, because
contrary to sections 941.30 sub 1,
she's had to really dance through the
939.50
fires
sub
with
3
this
sub
one,
F,
you know.
and 939.63 sub 1
But
sub
yeah,
B of the
it's tough.
Wisconsin statutes.
It's tough.
The 33rd count.
Yeah,
of
the jury
information in
can't
this
see.
Case
Yeah.
charges that Darrell E. Brooks, on or about
Yes,
Sunday,
they can.
November 21,
And the question is, can a jury see
2021,
Brooks or the
on
video?
Main Street
Yeah.
in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the
So I'm
safety of
wrapping the
Jennifer
poll over
Stover
here.
under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1
Good.
sub B of
Hold
the
his ejection sign.
statutes.
I don't like this.
The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of
Guys,
2021,
I'm not gonna have a lot of
on
time to
Main
wrap.
Street
This
in the
thing is-
city of Waukesha,
mouth might be full.
Waukesha County, Wisconsin, to recklessly endanger the safety of Alice Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Urell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that
I don't know if you're waving back at it, but I am. What's up,
on
dude?
Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin,
If you're gonna
did
plead guilty,
recklessly
say
endanger the safety of
ho.
Lola Hospel under circumstances which show utter disregard for human
Get 'em.
life and while using a dangerous weapon, contrary to sections
Sorry, but that's kind of fun.
941.30 sub 1, 939.50 sub 3 sub
I feel like I'm at a.
and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th
It's like
count
air
of the
traffic
information
controlling right now,
in
you
this
guys. If
case
you're
charges that
listening and not watching, he's
Darrell E. Brooks on or about Sunday, November 21,
lost at sea.
2021 on Main Street,
Spalding,
the city
Wilson,
of Waukesha,
whatever
Waukesha
his
County,
name was.
Wisconsin, did recklessly endanger the safety
He lost his
of Tamara
volleyball.
Rosentrader under circumstances
didn't
which
work.
show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statute. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, the 41st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Betty Strang under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 42nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statute. The 44th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 45th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Benjamin Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 46th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 47th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lori Loken under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 48th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Marisol Lopez Gutierrez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1,
Damn.
939.50
That's just,
sub
I mean,
3
this
sub 1,
is
and
horrible. Just
939.63 sub 1 sub B of the Wisconsin
all these
statutes.
people.
The
And while
49th
these
count of
victims
the
were
information
testifying,
in
you
this
had him up
case
there
charges that
objecting
Darrell
and
Brooks,
talking
on
about
or about
hearsay
Sunday,
and,
November 21
you know,
of
just
2021 on Main Street
Huh.
in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adair Lopez Rebelar under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Juan Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jason Petchloff under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 54th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Margaret Pachulis under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 55th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yamilet Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alin Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Ashley Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 58th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Jose Perales Alvarez under circumstances.
Sorry,
which show
guys, I'm not
utter
laughing at
disregard
this.
for human life
I
while
just
using a dangerous
heard an
weapon.
odd sound in the feedback,
Contrary
and I
to
look over and
sections 941.30
it's Jits just snoring away.
939.50 sub
Robert,
F,
Storia,
and
Leah, thank you for those
939.63
stars.
sub 1
Seriously,
sub
thank
B
you
of
so
the
much.
Wisconsin statutes. The 59th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Maria Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 60th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Camila Perez Gonzalez under circumstances which show utter disregard for human life and while
Nope.
using a dangerous
She
weapon.
asked him directly, what do you want to be called? What name are you going to go by? And nothing.
939.50 sub 3 sub F.
The question was, have we found out what his name is yet over on YouTube by Crispy? Thanks for the question, Crispy, but no, we don't have that yet.
Charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Isaac Foglia under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 62nd count of the information in this case charges that
Mind you, he's facing
Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to recklessly endanger the safety of Deborah
77
Ramirez
charges.
under circumstances which show utter
Drop
disregard
stars for that
human
math.
life and while using
Boom.
a dangerous weapon.
Quick addition.
Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B.
While she's reading these, a couple things I'm going to put up here, and I'll read through it while she's. And I know I'm talking over her, but
Darrell E. Brooks, on or about Sunday, November 20.
mass murder is the act of murdering a number of people, typically simultaneously or over a relatively short period of time, and in close geographic proximity. The FBI defines mass murder as murdering 4 or more people during an event with no cooling off period, quotations on the cooling off period between the murders. And mass murder typically occurs in a single location where 1 or more people kill several others. So
the 64th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lily Green under circumstances which show utter disregard.
feel free to reach out to me, guys. CJ at cjtv.live if you have any questions. If you yourself would like to come on the show, you have anything interesting you want to talk about, viewpoints that you have, we're going to be doing a lot of one-on-ones, kind of a common ground sessions. So I don't know what we're talking, but if you're watching right now and you want to go ahead and reach out, best way to do it is at the email on the screen there, CJ at cjtv.live. Send me a line. Let's chat.
Utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1,
right there.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
And as always, guys, set up notifications on all your channels. Like, subscribe, make that happen. Definitely follow.
In the city of Waukesha, Waukesha County, Wisconsin.
Facebook and YouTube, primarily.
The safety of
Twitch, if you're not over there.
Knapp under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 67th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen Ricciati under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. I'm going to take a quick stand break. Please stand, everyone.
Again, if you want to reach out to me for any reason, CJ at CJTV.live. I'm going to be doing one-on-ones with people. I'm talking common ground sessions from pulmonologists to park rangers. You know, it depends. Not that there's a comparison between the two, as a contrast, but it doesn't matter what you do. If you have another media channel, A1 Media, I know you were in here with us. If you're still in and you want to go ahead and do a studio session, we can talk shop about things that are going on, what's happening in the world. Hit me up. Anything you're doing, I'm really curious to talk to folks about your life and where you're at and what's going on in the world. And we can just kind of chit chat about things. Definitely want to have a chime-in session for folks that want to get in on it as well.
First-degree recklessly endangering safety, as defined in Section 941.30 sub 1 of the Criminal Code of Wisconsin,
right down here,
is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first-degree recklessly endangering safety, the state must prove by evidence which satisfies you beyond a reasonable doubt the following three elements were present with respect to that count. 1. As to each count, the defendant endangered the safety of another human being. 2. As to each count, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. 3. As to each count, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The information alleges not only that the defendant committed the crimes of first-degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner in it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 8, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8. If you find the defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 9, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 9. If you are not so satisfied, you must find the defendant not guilty as to count 9.
And a big shout out to
If you
A1
find the
Media,
defendant
guys in
guilty
the
of count
comments
9, you
here.
must answer the following question, yes or no. Did the defendant commit the crime of first degree
Check him
recklessly
out
endangering
at
safety while using
A1
a dangerous
Bakersfield
weapon?
Media on Facebook.
If you are satisfied beyond a reasonable doubt that all three elements of first degree
Tell him I said
recklessly
hi.
endangering safety have been proved as to count 10, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 10. If you are not so satisfied, you must find the defendant not guilty as to count 10. If you find the defendant guilty of count 10, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 11, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 11. If you are not so satisfied, you must find the defendant not guilty as to count 11. If you find the defendant guilty of count 11, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 12, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 12. If you are not so satisfied, you must find the defendant not guilty as to count 12. If you find the defendant guilty of count 12, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 13. If you are not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 14. If you are not so satisfied, you must find the defendant not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 15, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 15. If you are not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 16, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16. If you find the defendant guilty of count 16, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 17, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 17. If you are not so satisfied, you must find the defendant not guilty as to count 17. If you find the defendant guilty of count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, You should find the defendant guilty of first-degree recklessly endangering safety as charged in count 18. If you are not so satisfied, you must find the defendant not guilty as to count 18. If you find the defendant guilty of count 18, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 19. If you are not so satisfied, you must find the defendant not guilty as to count 19. If you find the defendant guilty of count 19, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 20, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 20. If you are not so satisfied, you must find the defendant not guilty as to count 20. If you find the defendant guilty of count 20, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 21. If you are not so satisfied, you must find the defendant not guilty as to count 21. If you find the defendant guilty of count 21, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 22, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 22. If you are not so satisfied, you must find the defendant not guilty as to count 22. If you find the defendant guilty of count 22, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 23, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 23. If you are not so satisfied, you must find the defendant not guilty as to count 23. If you find the defendant guilty of count 23, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
Yeah, keep in mind that after lunch, we will be going to the closing arguments. So stay tuned for that.
You should find the defendant guilty of first-degree recklessly endangering safety as charged in count 24.
Also, Robert, thank you so much for those stars. I appreciate you, my friend. Storia, Via,
If you find the defendant guilty of count 24, you must answer the
Anna,
following
Susan.
question, yes or no.
You guys are awesome. And for the
Did
shares,
defendant
thank you for
commit
the shares,
crime
you
of
guys.
first-degree recklessly endangering safety while using a dangerous weapon?
Yeah, she's got to work it out for it.
If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count
Do I
20,
think he's actually paying? No, he's over here doing this right here. Playing in his box board.
count 25. If you find the defendant guilty of count 25, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 26, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 27. If you are not so satisfied, you must find the defendant not guilty as to count 27. If you find the defendant guilty of count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 28, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 28. If you are not so satisfied, you must find the defendant not guilty as to count 28. If you find the defendant guilty of count 28, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 29, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 29. If you are not so satisfied, you must find the defendant not guilty as to count 29. If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 30, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 30. If you are not so satisfied, you must find the defendant not guilty as to count 30. If you find the defendant guilty of count 30, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 31, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 31. If you are not so satisfied, you must find the defendant not guilty as to count 31. If you find the defendant guilty of count 31, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 32, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 32. If you are not so satisfied, you must find the defendant not guilty as to count 32. If you find the defendant guilty of count 32, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 33, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 33. If you are not so satisfied, you must find the defendant not guilty as to count 33. If you find the defendant guilty of count 33, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 34, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 34. If you are not so satisfied, you must find the defendant not guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 35, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 35. If you are not so satisfied, you must find the defendant not guilty as to count 35. If you find the defendant guilty of count 35, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 36, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 36. If you are not so satisfied, you must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied.
Ooh, Mercedes, that's a solid
beyond
point.
three elements
He was
of
traveling
first
through the
degree
parade instead of
reckless
driving through the parade, because that's part of that sovereign argument.
7,
I'm not
you
driving,
should
I'm
find the
traveling.
defendant guilty of first-degree recklessly endangering safety as charged in count 37. If you are not so satisfied, you must find the defendant not guilty as to count 37. If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Yeah.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39.
I might have just smashed into my car outside. The guy's doing the lawn.
Answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? I've read 41 pages thus far. I am going to take a short comfort break, and we'll come back in about 10-15 minutes. This will also give the jurors and the parties a chance to have a comfort break as well. All rise for the jury.
No, I didn't. Who's in the courtroom? Is there somebody that I am unaware of that's in the courtroom that I need to know about? Tam, let me know. Man, stretch your legs, y'all. I know we got a lot going on. And I'm sorry if this is super loud. So appropriate. I should swing down there and say what's up. Yeah, they're on break. They're taking a
4 a.m., but I will address that when I get back on the record. We are in recess.
Make sure everybody knows that we are taking court is taking a 10-minute break. I'm going to call it a 10-minute break because that's where we're at. Basically, at this point in the juncture, they're going to be stretching it out a little bit. Sounds good to you, okay? It got a little loud, I know. Nobody of substance on YouTube. No one to even think about. They have a courtroom full of people. But, man, I'll tell you guys what. We were watching the video where she handed out 54 54 different objections the other day, last week. And just earlier today, he was talking about how she's prejudicing his defense, and he's had ample amount of time to do the full wage leverage of his defense. He's just decided to fire his defense team and go pro se, self-defended. And I'm looking at some of the information about pro se, about not about pro se, about being sovereign as well. This is the other part of it too. The Supreme Court decided that states cannot be liable for copyright infringement. Okay, each in Allen, Florida, the court analyzed the test that must be met for state sovereign immunity to. Okay, this is more for state. I'm not going to worry about all that. But man, I tell you what, Darrell Brooks here. We had him. Oh yeah, I was going to show you guys. This is when he was building his fort. So this is why Darrell Brooks can't be in a courtroom, because he does antics nonstop. And yeah, so one of those would be basically something like this. This is where he builds his box fort, which a Darrell Brooks box fort, you already know, you gotta, basically, this goes back to being a little kid. This whole box fort thing over here is, when you're a little boy, no girls allowed. Well, those are facts. Those are facts. No girls allowed in the box fort that you're going to be building, though. Not at all. But this was just Darrell Brooks, man. This guy.
As it relates to the jury instructions.
I'm just going through each one. I'm on page 50 of 107. Everything's looking great so far.
Okay. Fair enough. There's 107 pages. I certainly can give the parties some time to continue to read through them.
See him in his little box fort. I love when he looks around it. Like he does the whole peekaboo thing. Because he wants to be able to look at the monitors. There we go. I think this is what he's doing. He's got to make sure his corners are lined up. Now he's yelling. This is a previously recorded video, guys. This is from, I believe, yesterday. But he was yelling so loud that they could hear him through the walls, which is crazy. And
Mr. Brooks is requesting to go back to his cell at this point. I'm going to deny that request. He can remain in the other courtroom.
Again, he just thinks that he can bounce around and go where he wants, do what he wants, That moment. I'm sorry, guys, but just got to catch that moment right there.
Courtroom.
And this is Darrell Brooks in his box fort. And wants to screen grab that, absolutely do it. As a matter of fact, I'm going to do it right now, because these are the moments that are getting us through here, guys. Like, if it weren't for these, honestly, it would be tough to sit through this trial. And we can all agree on that, because this guy has made it, damn near impossible to not break your computer, your television. You okay over there, champ? Clumsy cat. While you're watching this, because the infuriating nature of this guy and the way that he's played it, the way he's been doing this, the back and forth, and coming in with these. Yesterday was, I don't understand. He just kept with the I don't understand. Then at one point, the judge finally said, listen, your ignorance of the law is not an excuse. It's not my job to coach you on how to litigate. Your job, because you're pro se, and mind you, he has done everything he's been afforded every opportunity. There's nothing that he has been denied. Even being put in a separate courtroom, he's not being held in contempt. He's not being removed from the proceedings. They've gone through and they made it very clear that all of the things that are happening in this courtroom that he's in, They even brought up the AV guys, the audiovisual guys, the IT guys in. They brought them into the courtroom and they had them on the stand as under oath that they were able to hear, see, and moderate the sound in that courtroom. They brought it. They even had the screenshots of the decibels and the audio readings to make sure that he could hear everything while he's in there screaming about, I can't hear you, I can't hear you. He took his headphones off. Well, then they were like, oh, well, let's turn on the speakers then while you're in the foyer or whatever you want to call it, your little clubhouse. Also, I'm taking polls on the best clubhouse name. So email me if you want to go ahead and get the clubhouse name. Maybe we'll brand it on the box fort we'll build. I'm just waiting for this cat to fall out a window. Yeah, so they're on break just for another probably 7 to 8 minutes. But I need an email, though, so I can't keep up with all the comments, guys. Email me if you have a name for the Darrell Brooks fort, box fort. I'd love to see it. And, who knows, maybe we'll put together some swag. We could all rock some Darrell Brooks box fort gear. Just the sad nature of this guy right here, man. This was him during his opening statements. He went from this to immediately calling the state of Wisconsin to the stand and then becoming the most irreverent piece of garbage ever. Like, this is when he opened his case. If you guys don't remember that, it was ridiculous. And he goes from that to this, that to this. But if you're not watching this and you're just listening, you're missing out, because I love this picture of Darrell Brooks in this box fort. And then it goes over to this right here where he's playing peekaboo around said box fort, which is I gotta laugh, man. I've gotta laugh. Hey, Kara, email me, please. Kara Hampton. No, really, I need you to email me. We need to talk. If you don't, in the mods, would you guys go ahead and put a note for contacting Kara Hampton? But yeah, this guy, man. Let's continue watching what happens with this one. I think he does it again. He's not actually reading the Bible on the other side of that either. You know what I mean? Oh man! Oh, look at now he's got to set up his perimeter defense for when the zombies attack the courtroom, or when the girls with cooties try to touch him. But that's fine, because that's not happening for the rest of your natural life, my friend. Sorry, not sorry. And then it's just dead quiet. They're like, all right, well, what's Mr. Brooks going to do? He's going to stay in his little box for it. But yeah, we can, let's add this ring here. So basically Darrell Brooks, just nonstop class act moron. He's not dumb, he's not dumb. And let's see, this was 5 days ago when Darrell Brooks was countering the state's offer of 6 life sentences, which, okay, if that's what you're doing, all right.
Yeah, just a quick question about the last thing again. I will be able to re-cross-examine.
Oh, yes, you will.
Just
and is essentially anything left off limits to my cross, or what?
I may limit depending on where we go. If the questions deal with what he testified to previously, it's primarily to cross-examine based on the new testimony. However, 90611 also says this: witness may be cross-examined on any matter relevant to any issue in the case, including credibility. It does say in the interest of justice, the judge may limit cross-examination with respect to matters not testified to on direct. So I'll give you some leeway, and I'll trust the state will make appropriate objections, and I'll rule on them if and when they're made.
Because I'm not intending to go too much back into the previous testimony, but I think it made a few points from the earlier testimony may come into play, and I just wanted to make sure.
I think that's fair.
That wouldn't be a problem.
I think that's fair, sir.
Also, really quick, I did look over some information provided by the prosecution as far as the pretrial offer that I did not have knowledge of until, I don't know if that was today, Thursday. I don't know if that was Monday or Friday or Monday, one of those days. I've put together, started to, I won't say it's completed. That wouldn't be fair to say. I've put together, or started to put together a counter offer. So I just wanted to advise the court that I was putting that together.
All right, thank you, sir. If and when you do provide that to the state, please let me know so we can make a record of that. All right, anything else? If not, then we'll have the jury brought out.
We do have one last large map here, Your Honor. I'm going to ask to put up and face backwards like we did.
So that was, Facebook user hit me up. The music video, TikTok music video, whatever that's going to look like. So these are some of the most recent Darrell Brooks. This is Darrell Brooks apparently corrected. There were some points that I just were so hilarious to me and then there's some that I totally missed, which is wild. This is Judge correct.
Position on that, I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying book. I'm looking at the Bible. Thank you.
It's not a book.
It's a book. It's the book.
Can't disagree with you there, sir.
It's not a book. It's a book.
I mean, people actually live by it, though. Anyway.
Who is he talking
Sir,
about?
I'm contemplating putting an hour.
He said about the Bible. He said, Judge, it's not a book. It's the book. And she said, I can't disagree with you there. He said, Well, how many people actually live by it, though? As if to say that Judge is living an evil life by having to preside over this case that he is making a ridiculous mockery of. I mean, hey, the guy has got a gift when it comes to asinine statements. If nothing else, he has made it remarkably clear how ridiculous he can be with his outbursts and his antics. Can you imagine if he had chosen to live by it? Yeah, absolutely. Even Ethan Crumbley, you guys, this happened just the other day. Just yesterday, actually, Ethan Crumbley, who killed 4 students and wounded others in a school shooting when he was 15 last year. No, sorry, I saw a comment that came through. But even he pled guilty to all charges. I'm talking terrorism, intent to murder, first-degree murder. I mean, he's a 16-year-old kid. He pled guilty. He knew he was going to prison for life, and that was part of his plan, as they found out in his journal, which is just a terrible case, man. The Oakland shooting was just a terrible case. But that kid stepped up and took accountability. But for whatever reasons, whatever motivation, even if it was his plan to begin with, whatever it might have been, he still is sitting down and saying, guilty. I did it. I'm guilty. And, I'm okay. I'm going to be spending life in prison. And that's where he'll spend, And Tabitha, who's we're talking about in Michigan here, didn't look good for his parents, who bought him the gun at 15 years old, just a couple days before the shooting. This is on another case, and we'll talk about this one moving forward. But they bought the gun for him at 15, showed him how to use it, and then was having counseling appointments that they were in the school with the school counselor the day of the shooting, hours before it happened. He had his backpack with his journal that said, I'm going to kill people, had the breakdown, had a checklist of what he needed to bring. He had everything in his bag that he need. It was leading up, and the gun in his bag with him in the school counselor's office with his parents, talking about him being problemed and the things that he was going through and what basically he was talking about doing. Fast forward a couple hours later, he shows up at school and he kills 4 students. And then his parents go on the run, and they catch his parents holed up in an abandoned building, planning on fleeing the country, apparently, with burner phones and some gift cards and, multiple ID apparently. So it's crazy. But but Darrell Brooks here, man, this guy, he's just, a world-class,
The time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The closing arguments will most likely be tomorrow.
I'm not doing it tomorrow.
He said he's not.
Then you'll forfeit your right to give one, sir, because as we have.
You can't force me. You can't force me not.
Whatever she wants, she's a judge.
Court is this where you can say you're going to force somebody not to be able to give a closing argument? How's that lawful law?
If you choose not to give one,
how's that lawful law?
Sir, if you choose not to give one, you're not letting me finish, and you're mocking me right now, which is incredibly disrespectful once again.
Okay,
you didn't even let me get my sentence out.
You always want to make an incorrect record. Go ahead. Change your incorrect record. Go ahead.
I'll mute him once
That was
again
before
because
the
Don't get brazen with
just
me.
wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow
giving
afternoon.
his closing arguments. He's saying, I'm not doing it. Nope.
Will do my very best
refuse to
with
finish
just
this case.
one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing argument.
All right. Well, they are back in. So I'm going to pull you guys back into court here. Sorry, guys.
Would you like to explain this on the record, or should I will, if you won't, I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I specifically advise that he would need to pledge to not interrupt the proceedings. He has not done that, meaning he has not indicated he wants to come back or that he will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will of course be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at. Anything further he wants to address, he will need to do that in writing, as he has done with a note, but I don't feel the need to give him any additional opportunity to explain that. What I will ask is he going to make a request to come back into this courtroom? And if that is true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr. Brooks, what is your request as it relates to coming back into this courtroom?
I've requested to come back into the courtroom with the first writing that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked when you've given me the opportunity, when I felt that the time was right, I've always asked to come back. Have I not?
Mr. Brooks, given your conduct this morning and your blatant violation of my untruthfulness, it's not specific not to interrupt when the jury was being evidence. I frankly wouldn't even felt that it's important to strictly enforce the language of Illinois.
Sorry, guys, I had to.
Allen, and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I hasn't been what it has been previously?
Mr. Brooks, we started the advisement.
You don't get brownie points for not being a piece of crap.
So I would thoroughly disagree.
You have to do your.
It might not have been volatile or loud, but it was nonetheless disruptive.
Absolutely, and you don't get bonus points for
I'll
not
ask
being
you these
a
questions,
piece of
sir.
human garbage.
If you come back into this courtroom, are you willing to honor
Yeah,
my
you would argue to
request
stop
in
sign.
order to you that you not interrupt as I read through the jury instructions?
Yeah, I don't understand the question that you're asking.
So are you willing to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr. Brooks, I'm not going to debate the meaning of Illinois versus Illinois v. Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum. So that's on you.
Let me know if the mic's okay. If this is good from here.
Never been
if you
done
guys can hear me
before.
all right.
It's never been done before, and I've always been able to reclaim my right to be able to be present.
Are you willing?
Which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen, which says the following. I will repeat myself again. Once lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I have not required the pledge previously. I've allowed you to come back. But given the interruptions this
He just
morning
can't maintain his
and your
decorum. It's not going to
immediate
happen.
discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
So where does it say anything about a pledge, Your Honor?
Sir, I'm not going to debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Your Honor, I didn't interrupt you while you were talking. I let you make your record without talking over you or interrupting.
Thank you. I would agree with you just now.
The way that I'm interpreting when you reference to me with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it to me now. That's why I don't understand what you're asking. I'm interpreting that in a totally different way.
I'd refer you to
I'm gonna keep
the
playing with the
third
mic, you
section
guys,
of
so we
Illinois
get it right.
versus Allen, where the
So
U.S.
let me
Supreme
know if it
Court was
sounds okay.
discussing what the trial court did in that case. And it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more opportunity, sir. You can come back into this courtroom, but I do not want you to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway, and that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right, then I'm going
to say the same thing.
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr. Brooks, I'm going to mute you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple. So we'll be in recess. He'll be brought back over, and then we'll start back up.
Well. The back and forth, the yo-yo of it all. You guys, it's just a nonstop thing here. Back and forth. Yeah, let me know how the sound is now. I'm playing with my mic setup. Also, Sam, I really appreciate the info. I'm going to work on that actually while we're doing things here. So I was just firing you back a letter, let you know what's up. So, hey, for everyone that's emailing me right now, I really appreciate it. And I'm glad that we're able to exchange information with each other. And, we're able to, do these things. Some of the questions you've been asking have been good and great. And I'm really looking forward to bringing some of you on the show. So yeah, you guys, if you email me, I will write you back, and it comes directly to me. It doesn't go anywhere else. There's no third party that filters things. We're here right here. It's between you and us, you and me. And I got to tell you though, I love this, guys. When he says, "I don't understand," I don't understand. Well, text man right here we go. Yeah. So when he says, "I don't understand," she should tell him to consult with the defense attorney and send him a mirror. Well, that's because your defense team sucks, bro. Your defense team is terrible, like really world-class garbage. And anybody could throw in the quotes here, like any man who chooses to defend himself has a fool for a client. I think is, what the, the court poetry on that one would be. But taking a break because of, Crystal Robbins says every time I log in between calls here at work, they're taking breaks because of his idiotic behavior. This is nonstop, man. He perpetually goes from courtroom to courtroom, and then he requests to go back to the courtroom. And it's just back and forth. And even when he was in his special fort room here, the fort room, there it is. It's not a courtroom, it's his fort room. There we go. So Darrell Brooks is right now in his fort room. He's getting removed from the fort room to the main courtroom. And then he'll be over there for as long as he can handle not speaking and bringing up legal issues that she's made very clear that she will immediately. And we did this the first time. Then we said, all right, how long is it going to take him before he gets removed from the courtroom? And people are putting in 3 minutes, 5 minutes, 30 seconds. He didn't even make it 1 second. The jury was like one step into the room and they removed him. They said, nope, send the jury back out. He's forfeiting his right to be in the room. Get out. Now they're not kicking him out of court. They're moving him to a separate courtroom. So he's gone from the courtroom to the fort room. And in the fort room, he's able to, 1 second. Yeah, he's able to hear, speak, and be involved and engage. He can see everybody, the jury. He can see everything what we don't see. Obviously, we're not able to see the jury, but the way he's working this is done to, he's stalling as much as he possibly can. It's a real testament to the patience of. I'm amazed that, and here's the thing. I'm amazed that people in the courtroom that are in the back that are watching, that they haven't said anything. I mean, really, we're watching some of the things he says, and it's just kind of like, it would be hard for me not to say something. Like I'm without question, I would be kicked out of that courtroom. They would definitely boot me. I would be thrown out in a heartbeat because I would say something, and I don't know if I would get in trouble for that. Like, anybody in here know what happens if you give an outburst in court? Like, without being warned, if you don't do anything really bad, maybe you say something like, I don't know, somebody might say like, dude, you're a raging piece of human garbage and you're a hemorrhoid on society, and I'm looking forward to you spending the rest of your life in prison. They're like, hey man, you can't say that because this is court and you're not allowed to talk like that. You got to get out of here. Or would you get brought up on charges? Because it gives me thoughts as to where I might navigate myself for the end of the day and or tomorrow. So we'll see. Held in contempt, you'd get arrested. Ooh. Peter Pan says I'd get arrested, and then Ever says I'd get held in contempt. Well, Brianna, I am a news affiliate. It's a recognized media organization, CJTV Media LLC, and yeah. Oh man, did you guys? Okay, let me show you real fast if I can. This is the judge in the Ethan Crumbley case. This dude terrified me. Like, even just listening to when Ethan Crumbley was let me play this for you real fast. Pleading guilty yesterday to the shooting in Oxford. The judge, man, this judge is no joke. This dude legit sounds like a drill sergeant. He comes in hard, and he doesn't. I haven't seen any of there hasn't been a trial moving up to this. Like, the parents are supposed to go on trial yesterday, and they moved that trial to a later date. And Ethan came in. They knew, I think, on Friday that he was going to do it, but he came in on Monday, yesterday, and pled guilty to yeah. So here, I'm going to pull this up real quick, but just I really want you to pay attention to the judge in this one, because he really is. I mean, the dude is no joke. And so we're going to go ahead and do this. Sorry, I gotta do this. Play around with this for a second. And all right, boom. So listen to the judge. This is Ethan Crumbley.
Good morning to all counsel. Today's date and time set for a pre-trial this morning. How would you all like to proceed?
Judge, it's my understanding that the defendant is going to plead guilty to all 24 counts.
Thank you.
That is our understanding as well, Your Honor. First, we filed a notice asserting the defense of insanity on January 27th of 2022. At this time, we are withdrawing that notice and we'll be proceeding with a guilty plea.
Thank you. And I will let all counsel know you may remove your mask if you're comfortable.
Thank you. My client has completed a plea form. May I approach your clerk?
You may.
Judge, for the record, we've also executed a written statement of guilty plea for the court.
Thank you.
Now, listen as the judge reads the charges.
Thank you. With that being said, is there anything else we need to address before I take your client's plea, Ms. Lofton?
Your Honor, I would ask the court to inquire of Ms. McKelvey as the LGAL if she had time to meet with.
So this judge is, I mean, he's no joke. Not that I'm saying Judge Darrow is. That's not what I'm saying. Don't think that for 2 seconds. I'm not laying that out there at all. What I'm saying is that the way Darrell Brooks deals with women, 100% different than the way he deals with men. Even in the way he's asking questions. When he was when Abel or Abel was brought on stage, the big Hispanic fella who has a rap sheet, you know, whatever. Big dude. Immediately, Darrell went into beta form. He shrunk down. He was looking down. He would kind of glance up. He never once did he even give any of his antics. But the dude was leaned in. He was like, well, this is what I saw. These are my answers. This is what you get.
And what the
Lofton and I special doesn't.
But they're going to read through.
No, Judge, thank you.
Or affirm that the statements you're about to make will be the truth?
Yes, I do, Your Honor.
Thank you. You put your hand down. What is your name?
Ethan Robert Crumbly.
And Mr. Crumbly, how old are you?
I'm 16 years old.
Can you read, write, and understand the English language?
Yes, sir.
Can you hear and understand me, the prosecutor, as well as your attorney?
Yes, sir.
Are you satisfied with the advice your attorney is giving you?
Yes, sir.
And you also have been appointed another court-appointed attorney as well as a legal guardian ad litem. Did you have an opportunity to speak to your legal guardian ad litem?
Yes, sir.
And having spoken to your legal guardian ad litem, are you still prepared to proceed this morning?
Yes, sir.
And you're comfortable with proceeding?
Yes, sir.
You understand that you have the right to have an assistance of an attorney throughout all proceedings. And if you cannot afford an attorney, the court would appoint one for you?
Yes, sir.
You understand that you will be pleading guilty to count 1, terrorism causing death. That is a felony where you face up to life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You may have to reimburse the government for expenses incurred from the violation. You're also charged in count 2, first-degree premeditated murder. That is a felony where you face up to life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 3 with first-degree premeditated murder. That is a felony where you face up to life without parole. Or
even the presence of this judge, like as he reads, and this goes on, we're not gonna be able to watch this whole thing because this goes on for, I believe, like 15 minutes, but and they'll be back in court before that. But the way he even reads through it it's almost like he's not breathing. Like he's about ready to tell someone to do push-ups. He's just got a commanding presence. And Darrell Brooks would have, can you imagine? I can't imagine even Judge Schroeder, because he's not like young, powerful man. He's like that old, I don't give a damn judge. Like, you know what I mean? Like Judge Schroeder's, you know,
Pardon me?
That was before the
Don't get brazen with me.
That's your Judge Schroeder. Judge Darrow's been in a very different situation, mind you, because she's had to navigate the waters of avoiding a mistrial, avoiding opening the door for the appeal process. So all of this goes into the fact that she's had to go through a very different minefield of a case. But this judge, if you just listen to him,
or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 4 with first-degree murder. That is a felony where you face up to life without parole or a minimum of sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 5 with homicide, first-degree murder. That is a felony where you face up to life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. You're charged in count 6 with assault with intent to murder. That is a felony where you face up to life or any number of years. You're charged in count 7 with assault with intent to murder. That is a felony where you face up to life or any number of years. You're charged in count 8 with assault with intent to murder. That is a felony where you face up to life or any number of years. You're charged in count 9 with assault with intent to murder. That is a felony where you face up to life or any number of years in prison. You're charged in count 10 with assault with intent to murder. That is a felony where you face up to life or any number of years with the Michigan Department of Corrections. You're charged in count 11 with assault with intent to murder. That is a felony where you face up to life or any number of years, again, with the Michigan Department of Corrections. You're charged in count 12 with assault with intent to murder. That is a felony where you face up to life or any number of years with the Michigan Department of Corrections. You're charged with count 13, possession of a firearm in the commission of a felony. I will note for the record that you're charged in counts 13 through 24, all being felony firearm offenses. Counts 13 through 24, you face 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony conviction. You understand the maximum possible penalties you face here?
Yes, sir.
You understand that the maximum possible penalty you face here on the underlying offenses is up to life in prison?
Yes, sir.
And that would be life in prison without parole. You understand that?
Yes, sir.
The arguments Darrell Brooks would have for all of this already, like he was arguing just 5 days ago, he was arguing about the life sentences and not putting up with anything the judge was saying. Nothing. You've seen it. He's like, I don't know what the hell you like. The brash audacity, and I'm hopefully I'll be able to put together a compilation of clips that is just all of these incredibly disrespectful and just like unbelievable, really unbelievable outbursts that we've seen from Darrell Brooks from the beginning of this trial. And we're going all the way back to the when he was a very first there. Now, the man that you see with Darrell Brooks is very different because this is what he became when he was in his opening statements, right? Like this was Darrell Brooks, telling the jury, you have a decision to make, the power's in your hands, blah, blah, blah. I hope you make the right choice, and he's crying looking at him. This guy is crying looking at him. And the whole time Darrell Brooks is crying looking at him, all I can think is you're right. He does look like one of those monsters from The Fifth Element. He's just 100%. Like that is, you can't argue that over there that's not what he looks like, because that's definitely what he looks like when he's not hiding behind his box fort, making sure you can't see him. But the difference in the presiding over these cases, like the judge right now, Darrow, has her hands tied. And if you haven't been with us the whole time, you haven't been able to see things like Darrell Brooks holding up his little objection sign. But this is definitely Darrell Brooks. But you haven't seen that even the prosecution at one point said, listen, you have the opportunity and the right to tell him to sit down and be quiet, and you haven't, and then she immediately falls, and we know why, and we appreciate it. So there is so much more happening than just your typical litigation of a case. Like, and I hope I'm using that term properly. We're at a position right now where this may be a precedent-setting case, but we'll find out. Darrell Brooks is in he never made it over, apparently. So we're going to bring you back into trial here, guys.
Very clear, I believe, what this court's expectation is, that I continue with the jury instructions without interruption, that Mr. Brooks follow the rules of courtesy and decorum. He's had those for quite some time, and that he conduct himself consistently with the dignity and decorum that these proceedings deserve. And that includes not interrupting or bringing up legal matters that this court has previously ruled on. We have lost a significant amount of time now addressing, or not even addressing, but Mr. Brooks really interrupting the flow and the proceedings. based upon his responses, and then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to this court, not an ambiguous one, but a very clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that,
okay, I thought they were opening the door for him to do it right now.
To be present in this courtroom as I instruct the jury. So with that, I did give him 5 minutes. I said, you have 5 minutes to decide. I set a timer. It went off. He is still in the other courtroom. We are going to continue. So the jury is to be brought out.
Like a child, man. He's got an 8 timer. You're on timeout until this dings. You know,
was working just fine.
Wow. So they've confirmed the audio is working fine. His how's the audio on our side, guys? Is it too loud still?
Should further indicate he continues to be muted.
Had to play a little bit with the mic sound. And again, Sam, thank you. We'll get that adjusted today.
With the court, he needs to put it, write it on his pad of paper.
You are 100% correct with that, Brianna.
At the appropriate time.
And then Carol, yeah, the best thing we can do is have him muted. You know, the best thing we can do is keep him muted and avoid us having to deal with him and his nonstop outbursts, because we're not able to get through anything. Now they're bringing the jury back in, and they have to go through the process of.
I just want to put on the record that at 11:01 I took the break. It's now 11:48.
So look, I appreciate that.
So I intended to take 10-15 minutes tops. And Mr. Brooks, you can write it down. I'm not going to interrupt further. The jury's coming out.
Nobody's rioting for this guy. Nobody's. Yeah. Oh, he's big mad. Big mad. Here comes the tantrum. I'm not even going to wear these headphones. Y'all can't make me wear headphones. I'm not wearing the headphones. Tell me to wear headphones. I'm not doing the headphones. Yeah, she's muting him. I love it when she does it. The best is when she mutes him, and if they keep the camera on him, guys, it's hilarious because he'll be talking, and he's like, God, I say, all right, I'm going to mute him. He's not, whatever. Boop. And then the camera's still on him. He's like, ah. And you can see him boil over, and then he'll start, at times he'll start slamming his fists on the table, and it's just, it's the best. It's the best, honestly. It makes all of this almost tolerable when we get to see him shut down and shut up and put in his place, man.
Thank you, everyone. Please be seated.
So sad. So sad.
Then with the jury instructions, if you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 43, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 43. If you are not so satisfied, you must find the defendant not guilty as to count 43. If you find the defendant guilty of count 43, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 44, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 44. If you are not so satisfied, you must find the defendant not guilty as to count 44. If you find the defendant guilty of count 44, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 45, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47. If you find the defendant guilty of count 47, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 48, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 48. If you are not so satisfied, you must find the defendant not guilty as to count 48. If you find the defendant guilty of count 48, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 49, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 49. If you are not so satisfied, you must find the defendant not guilty as to count 49. If you find the defendant guilty of count 49, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree reckless endangering safety have been proved as to count 50, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 50. If you are not so satisfied, you must find the defendant not guilty as to count 50. If you find the defendant guilty of count 50, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 51, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 51. If you are not so satisfied, you must find the defendant not guilty as to count 51. If you find the defendant guilty of count 51, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 52, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 52. If you are not so satisfied, you must find the defendant not guilty as to count 52. If you find the defendant guilty of count 52, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 53, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 53. If you are not so satisfied, you must find the defendant not guilty as to count 53. If you find the defendant guilty of count 53, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond
We're getting there,
a reasonable
guys.
doubt that all
We're getting
three
through it.
elements of first
We're getting
degree
there.
recklessly endangering safety have been proved as to count 54, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 54. If you are not so satisfied, you must find the defendant not guilty as to count 54. If you find the defendant guilty of count 54, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 55, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 55. If you are not so satisfied, you must find the defendant not guilty as to count 55. If you find the defendant guilty of count 55, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 56, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 56. If you are not so satisfied, you must find the defendant not guilty as to count 56. If you find the defendant guilty of count 56, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 57, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 57. If you are not so satisfied, you must find the defendant not guilty as to count 57. If you find the defendant guilty of count 57, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 58, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 58. If you are not so satisfied, you must find the defendant not guilty as to count 58. If you find the defendant guilty of count 58, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety by using a dangerous weapon? If you are satisfied
That's the
beyond a
plan,
reasonable
guys.
doubt that
After
all
lunch,
three
they plan on doing
elements of
closing
first
arguments.
degree, recklessly endangering safety have been proved as to count 59, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 59. If you are not so satisfied, you must find the defendant not guilty as to count 59. If you find the defendant guilty of count 59, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 60, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 60. If you are not so satisfied, you must find the defendant not guilty as to count 60. If you find the defendant guilty of count 60, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 61, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 61. If you are not so satisfied, you must find the defendant not guilty as to count 61. If you find the defendant guilty of count 61, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 62, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 62. If you are not so satisfied, you must find the defendant not guilty as to count 62. If you find the defendant guilty of count 62, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 63, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 63. If you are not so satisfied, you must find the defendant not guilty as to count 63. If you find the defendant guilty of count 63, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 64, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 64. If you are not so satisfied, you must find the defendant not guilty as to count 64. If you find the defendant guilty of count 64, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 65, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 65. If you are not so satisfied, you must find the defendant not guilty as to count 65. If you find the defendant guilty of count 65, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 66, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 66. If you are not so satisfied, you must find the defendant not guilty as to count 66. If you find the defendant guilty of count 66, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 67, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 67. If you are not so satisfied, you must find the defendant not guilty as to count 67. If you find the defendant guilty of count 67, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? The defendant is charged with 6 separate counts of violating a duty after having been involved in an accident resulting in death. The 68th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Virginia Sorenson and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name,
This is a big deal
address,
right
and the
here.
registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant or of or person attending any vehicle collided with and render reasonable assistance to any person injured in the accident including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to Section 346.67 sub 1 and 346.74 sub 5 sub D and 939.50 sub 3 sub D of the Wisconsin statutes.
She's got a lot going on. That's a lot of reading, man.
The
That's a
69th
lot of
count
reading.
of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Leanna Owen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to Section 346.67 sub 1 and 346.74 sub 5 sub D and 939.50 sub 3 sub D of the Wisconsin statutes. The 70th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Tamara Durand and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 71st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Kulich and failed to reasonably investigate what was struck and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 72nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Wilhelm Hospel and failed to reasonably investigate what was struck and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 73rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jackson Sparks and failed to reasonably investigate what was struck and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5, sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. Section 346.67 of the Wisconsin statutes, commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck, and if the operator knows or has reason to know that the accident resulted in death of a person, fails to stop the vehicle he is operating as close to the scene of the accident as possible, and remain at the scene of the accident until the operator has given information and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present with respect to that count. 1, as to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set in motion.
100% right, Caitlin.
As to each
100%.
count, the defendant knew that the vehicle he operated was involved in an accident on a highway. 3, as to each count, the defendant violated a duty after being involved in an accident. A driver who is involved in an accident has 2 duties. The state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the 2 duties, but you are not required to agree as to which duty was violated. The first duty is to reasonably investigate what was struck. The second duty is that a driver involved in an accident involving a person must stop and provide information and render aid. To prove a violation of this duty, the state must prove the following beyond a reasonable doubt: that the defendant knew or had reason to know that the vehicle he was operating was involved in an accident involving a person, and that the accident resulted in death of a person.
Yep, the people bouncing literally off the hood of his car.
Did not immediately stop his vehicle as close to the scene of the accident as possible and remain at the scene until he had done all of the following. A, give his name, address, and the registration number of the vehicle he was driving to the person struck. And B, if it was requested and was available, exhibit his operator's license to the person struck. And C, rendered reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or is requested by the injured person. 4, the defendant was physically capable of complying with these requirements. You cannot look into a person's mind to find knowledge. What a person knows or has reason to know must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in the death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question, yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorenson? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Tamara Durand? And I will specifically address Mr. Brooks at a later point. Count 71. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68.
I think Darrell Brooks has to go potty, maybe.
You must find the defendant not guilty.
But again,
find the
he's in his
defendant
courtroom
guilty,
right
you
now.
must answer the following question, yes or no. Did the accident involve death to Jane Kulich? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 72, you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospel? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with 2 separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code
He's
of
waving a
Wisconsin,
Bible at the judge.
is committed by one who has been released
he's
from
stretching, is
custody
what he's
on
doing.
bond and intentionally fails to comply with the terms of the bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on, bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of his bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply.
Don't feel bad. That's how we get through this, you guys, all together.
The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run, resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definition here. Battery will be defined in just a bit, and you should apply that definition here as well. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75.
And I want to say this real
If you
quick,
are
even though
not
I'm over
so
talking. That's what we need to be
satisfied,
clear
you must
about,
find the
guys, is
defendant
that there is
not
no
guilty as to
laughter
count
at
75.
the severity of this case or the people that have been
The
affected
76th
and the
count of
victims.
the information in
I
this
use laughter to
case
get through all my hard times.
charges
And
that
if we
Darrell
can't
Brooks,
clown
on or
at
about
Darrell
Sunday,
Brooks and his
November
antics
21 of 2021, near
him,
Flame Park in the city of
I think that would have imploded.
Waukesha.
So laughter,
Waukesha County,
levity
Wisconsin,
that's gone
did cause
towards
bodily
Darrell
harm
Brooks, not being pejorative towards the victims or the
to Erica Patterson by
situation
an act done
and
with
the
intent to cause
terrible,
bodily
terrible
harm to
events
that
that took place
person
last November.
without
So,
that person's consent.
thank you, Mo. And
contrary
don't feel bad
to
about that, guys.
section
We're allowed to
940.19
go through this.
sub 1,
How we need to go through it.
939.51 sub 3 sub A, and 968.075 sub 1 sub A of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present. 1, the defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2, the defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3, the defendant caused bodily harm without the consent of Erica Patterson. 4, the defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. I want to go back to the bail jumping because the battery is not part of that charge. And there's an inclusion of that in the jury instruction that I will have corrected. So I'm going to read the definition, the substantive instruction on bail jumping once again, starting with what the charges are. Well, the charges I've already read, they will stand. So bail jumping, as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, or hit and run resulting in death. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge.
Thank you, Matthew Beam, over on Face or on YouTube for that super sticker. And your rockstar, brother. Appreciate you.
And from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as
you guys, the Star Wars.
If you are not so satisfied,
thank you so much, you guys. The contributions like that makes this possible. So.
If you are satisfied beyond
penny,
a
a nickel, a
reasonable
dollar,
doubt
a
that all
five,
3
doesn't matter, you guys.
elements of bail
Anything you
jumping have
contribute
been
makes a
proved
huge
as to count
impact and
75,
difference.
you
I know I'm
should find
talking
the
over her right
defendant
now,
guilty of
but
bail jumping as
thank
charged
you guys,
in
and don't feel bad
75.
if you're able
If
to
you are
just
not
share
so
the stream out,
satisfied, you must
and that's what
find
you
the
can do.
defendant
Great.
not guilty as to count
And while
75.
I'm doing what I need to do to keep the lights on, keep the cameras rolling, you guys, the stars and the super chats, super stickers, Matthew Beam, and everyone else, Carla, everyone, you guys greatly appreciated. Seriously, it doesn't go unnoticed, and it doesn't fall into a big empty bucket.
And information
It all goes directly
is
towards
nothing
making this
more
happen.
than a
So
written,
you guys definitely are a
formal
big part of
accusation
making
against a
the community
defendant
that we have, and
charging the
about
commission
dragging
of
it
one or
forward.
more
So
criminal acts.
with your comments
You are
and with
not to
the
consider
emojis,
it
the
as
spamming
evidence
hearts,
against
whatever
the
you do.
defendant in any way. It does not raise any inference of guilt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself.
Julie, Bella.
The defendant has
thank you
decided to
very much.
represent himself, and this decision must not influence your verdict in any manner. At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any way. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by the witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider the witness's opportunity for observation, how long the observation lasted, how close the witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear the events, and any other circumstances of the observation. You should also consider the period of time which elapsed between the witness's observation and the identification of the defendant and any intervening event which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant.
You guys are amazing, man. You guys have been killing it with the
evidence has been presented relating to the defendant's
Star Wars
conduct
we have going
after
right now.
the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe deserves under all of the circumstances. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object
Are you
to
able to
what they
do a video
consider
call?
are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You
Like I
should
said, I
not
would
draw
send
any
you a link
conclusions from the fact
in my
an
studio
objection was made.
on Facebook
By
or
allowing
email,
testimony or
and
other
you
evidence
just
to be
go into
received
that
over the objection of
and
parties,
use your phone,
the court is not
or if
indicating
you
any
have a
opinion about the
webcam
evidence.
and a
You
decent
jurors are
microphone
the
style
judges of the
setup
credibility
of
of
any
the
kind.
witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of
Sorry about
evidence
that,
does
guys.
not
I'm
depend
conferring with
on
an
the
attorney
number
right
of
now about
witnesses
coming
on
on
each
for a
side.
moment
You
and
may
kind of
find that
walking
the
through some of this
testimony
with
of
us.
one witness is entitled to greater
I bet.
weight than that of
The
any
mute thing
other
for me is
witness,
tough too.
or
Obviously,
than
it's tough
that
with
of
Darrell
another
Brooks,
witness,
but
or
you know,
even of several other
what are you gonna do?
witnesses. Remarks of the parties are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors: whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which
Thank you,
tend
Debbie.
either to support or
Marianne,
to
thank
discredit
you.
the testimony.
Jet lag,
And
thanks for
give to
joining
the
us. Yeah.
testimony of each witness the weight you believe it should receive. There is no
Thank you,
magic
James,
way
as
for
well,
you
yeah.
to there is no magic way for you to evaluate the testimony.
What are you
Instead,
gonna do?
you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. Evidence has been received that two of the witnesses in this trial have been convicted of a crime. This evidence has was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, wait. At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch hour for closing arguments. All rise for the jury.
Yeah, what an amazing team we got here, man. Super great team. All right. So I'm going to go ahead and bring on board an attorney.
All right, thank you. Be seated. As soon as the doors close, I just need to put a couple
Based
things
out of
on the
Houston. We're going to do we're going to chat a little bit about what's going on here and get some input from someone who actually knows
As I read,
what they're talking
the
about.
doors closed, right? There we go. As I read through the bail jumping, it dawned
Hey.
on me that the
Hey, how are you?
I am fantastic. How we
is not
doing?
on Main Street.
Good. This is an interesting case.
It is a very interesting case. I know we're going to have some comments. I know
way
because
that the charge and the information
we've got
reads, and we
Darrell
had that
Brooks
discussion
is,
preliminarily, which is why
in a
later
side room,
on it
and the judge is
doesn't
still
reference
talking.
the instruction for battery. So I
she's
cleaned
going over
that
special
up
instructions with the
by
jury right now.
rereading it and taking that out. So I wanted to make a
And I
record
believe,
of that.
but let me turn her
obviously
down
I
a little
will
bit,
need
guys.
to
And
have,
so as we're in
new
here,
set
I want to make
made
sure
that
that we
has
open the
that,
door for folks to ask some questions
correction. And I apologize for not catching
from an
that
actual attorney.
previously.
So tell us who you are and what's going on.
So my name is Loa A. Lou Claycow, and I'm an attorney who's worked in the federal courts. I've worked in private practice. I've been in government work, and I'm mostly a litigator. And so I do spend a lot of my days watching these trials, just like I'm sure you and your viewers do.
Yeah.
It's, this is an example where, at least from what I've watched, the judge is exceedingly patient. It's a very difficult kind of case for a judge to have.
Mm-hmm.
And, it's a testament to the fact that nobody should be their own lawyer. No one should ever be their own lawyer.
Have you ever seen a case where someone's defended themselves and it's actually worked out to their benefit?
I've seen lawyers who defend themselves who have blind spots. So even lawyers who are well-trained and understand the law, understand the rules of evidence, can have blind spots, right? They're proving their own point. So they think they're coming across and making a point that they're just not making. They will forget things they've known for years, right? So you're an attorney and you're doing well, and then you all of a sudden get smacked by the judge or sanctioned by the judge. So I've never seen it work well. I was in a federal court case and working for the courts, and I was observing where we had, I believe it was 8 bank robbers, and 2 or 3 of them were sovereign citizens who were representing themselves. And it was definitely worse for those who were representing themselves as sovereign citizens than for those that had lawyers. I mean, even for the same crime.
Right. So the sovereign citizenship thing is interesting. I know a lot of people have. Are you able to hear what she's saying as well? Are you seeing?
Am I able to see what the judge is saying? I can read through it. It's a little harder to cover while talking.
Oh, okay.
She's doing jury instructions right now.
Arguments. I will also.
She's just giving, and I want to make sure
advise
people
Mr.
that are
Brooks
watching
that
understand that
given
they're not
that,
missing anything, that she's just
moving on
telling
to a
everybody kind of
second part of this,
process
that being the
procedure,
closing arguments,
which
he,
doesn't matter much because it's not like
will
he's
be,
maintained any kind of decorum or any
invited
kind of
back
like,
into the courtroom
any adherence
here
to the policy
for
of
those
the court
closing
proceedings.
arguments. Of
No,
course,
but
subject
the
to,
jury instructions are important, right?
his
When you think
conduct,
you know what you're doing, and then all of
I
a sudden you're in
expect
the
that he
jury
will
box,
follow the
and
rules
you're
of
like,
courtesy and
gosh, what do I
decorum,
do? And you know, you
and
saw this morning
also
where
not raise legal
she let him
issues in
know
front of
that he
the
needed
jury
to behave himself
when they
and have
appear.
decorum in front of the jury. And that's because it's very
We will
easy
take
to
our lunch
prejudice a jury,
recess.
right? With an
It's
outburst, with something you say.
12:47.
And once you've
We'll take
ruined
an
a
hour and
jury
15
pool,
minutes. Thank you.
depending on how severe it is, you can have to start all over. And so what happens when the jury is in the room, the instructions that are given to the jury are sacrosanct.
Explain to us what sacrosanct is.
So it's like, I don't know, I'm going to use a cooking analogy. So you could be making a souffle, you could be, have everything well prepared, you could have done everything else right, yet you say or leak the wrong thing to the jury, and it ruins the whole thing, which means they've now been prejudiced to the point where you even have to do a new jury selection. You've got to have a new trial. And there are defendants who will try and create one of those situations themselves. I'm sure you watched the school shooting, Parkland shooting trial. And while that came out surprising, I believe, for everyone, the number of times that the defense argued that information had been given to the jury that was prejudicing them, those are all grounds later, if the jury had found differently, that they could have overturned the ruling or the judgment. And so each of those decisions, if you show a jury something like a swastika, right? You show them that, you can't undo that. You can't take that back. And so, let's say there's one juror or two jurors who are Jewish, and then the argument's there, hey, we didn't prepare for this in jury instructions. We weren't, we can't take this back. You can't unsee it. There are some things you can tell a jury to ignore, but they're just not going to be able to ignore, or you don't have a high level of confidence that those are going to be ignored.
And we've heard that so many times. The jury will strike that, the jury will strike that, the jury will strike that. But I mean, you can say that all day, but like you said, you can't unsee or unhear something. That's not how it is. And he's doing a phenomenal job of these little audio bombs. He'll throw something in there. And so to some of the points that are coming up, we've got one of them, of course, is and I think I have it right here, is he keeps talking about subject matter jurisdiction. Subject matter jurisdiction. Could you give us a 2-second breakdown of like what subject matter jurisdiction is as it pertains to this case?
Sure. Well, there's two kinds of jurisdiction. You're going to have jurisdiction over the person and jurisdiction over the case. Okay. And so jurisdiction over the person, I usually see over the person when it comes to sovereign citizen, by the way, that says, hey, you have the power to make the decision over this person. And that's established at the very beginning of the case. Jurisdiction is fundamental to having a case. Subject matter jurisdiction means this court has the jurisdiction to hear this type of case. Right. So the subject matter is before the court.
So that plays into the sovereign citizen deal.
Jurisdiction over the person usually has more to do with it. You don't have any authority over me. The subject matter, it goes to the fact of the case where it's a terrible argument for someone to make over a sovereign citizen, because sovereign citizen is established in a way that they're basically saying the federal government or the government has no jurisdiction over me. I am not subject to the laws, the rules of this court, of the government, of this establishment. Subject matter jurisdiction, this is a crime. This is a court that has the ability, has been given the jurisdiction over crimes. The argument for subject matter jurisdiction doesn't even make sense here.
Right. Now, the other thing he's saying is that he hasn't had time to prepare his case. Now, we know that he's had a defense team up until just before jury selection that he released, and they allowed him to go pro se. So when you self-represent, how do you feel the judge has been handling that? Because I know a lot of people are really fed up with the leniency that she's given him with everything. And I guess move past the pro se, the outbursts, the way that he's flat out just yelled at the judge. He's threatened the judge. She's felt threatened.
Right.
And any attorney would be thrown out immediately, held in contempt. And he's pushing for that contempt. Why is he doing that?
So it's easier to understand why she is being so lenient.
Okay.
And it's not to help him. The fact is, any argument he makes where he may have not been given an opportunity, where he didn't understand something, at that point, it's a point of appeal, which means it's an excuse he can use later. The reason she's so careful is not to help him. It's to take away every excuse that an actual attorney can use to overturn whatever judgment comes at the end of this trial. If she is not very careful, one of those can be successful. One of the most common here, that he was not given the opportunity to present evidence, that he was not given the opportunity to present his best defense. When it boils down to it, I am glad. If you want to see him convicted, which a lot of people here do, you want her to be as careful as absolutely possible. Right. Not because he's going to have a great argument on appeal, but a good defense attorney, they'd have a good argument on appeal. Listen, my client had no idea what he was doing. He didn't have this opportunity. He didn't understand. Anytime you see a judge say, "Do you understand?" or explain something like they are to a 2-year-old, it takes a defense attorney's excuse away when they say he did not understand. And so, no, I think she's done an excellent job of this. I think an attorney would have a very hard time. You asked about time to prepare. He probably feels like that. He's probably telling the truth. When you're, pontificating in your cell and you think you're brilliant and you've read, blogs about the law and you've talked to your prisoner next door.
Jailhouse counsel.
Absolutely. You're probably like, I have got this. But when you're sitting there and now the judge has made a ruling that you don't understand, you feel unprepared. Do you remember, I believe it was yesterday, where he had the box of his information and he was being asked, do you have any questions for this witness? Do you have any new information that you haven't already asked? He was completely out of his element. He had no idea what to say. That kind of not being prepared isn't going to go by.
Well, they mentioned that when they were talking about the order in which they were going to call his witnesses, because he didn't want to allow the prosecution time to prepare their cross-examination for which his witnesses were damning at best. Like they did nothing. But I feel like those were witnesses that were pre-set up by his defense team. And I think once he took over, he had that list and he didn't know what to do with them. All right, well, I need to call these people, but they've been subpoenaed, but I don't know what to do with this. And then he flat out said to the judge, he's like, well, what am I supposed to ask him? And I loved it when the judge is like, well, that's your responsibility. You're your own attorney. And it was amazing because that's really what it is he's decided, like, I'm playing attorney. Like, I would never imagine that I could do your job. Like, I had to go to court for a restraining order that I was filing. And it was an abyss of confusion. Like, I had evidence that I tried to enter in. He was like, no, you didn't do this. And then I tried to bring in these statements. He's like, no, that's hearsay. You can't do that and this. And I was like, I was so frustrated because my hands were tied. I was like, well, what can I do?
Yeah.
And I was in the right. But in this, I see him. There's so much you have to know. I mean, you practice law. You have to keep working on it, right? Like,
you do. And even when you're a lawyer and you've passed the bar and you've done all of that, the first time you go into a courtroom or do a deposition, you're still nervous. And I got to be honest, to be a good attorney, you've got to be a little bit confident. You have to be willing to walk in there confidently and go for it. And there are times in this trial where you can see the lack of confidence. You think he's being confident, but he's not.
Well, no, I think that he's just really good at performing. He's got a very polished veneer of courtroom presence. He knows the term. He's just mimicking. And these are like your typical narcissist. And like the chameleon aspect, what I've seen is he's able to watch what the attorneys are doing over here and say, oh, okay, I like the way they're asking questions. That seems to go well with the judge. So the whole fair to say, to the best of your recollection, and the way he's gone about his questioning with his witnesses or with the witnesses has been nothing. I mean, it just makes him look like he knows what he's saying. But with the questions he's been asking, do you feel that any of that's been geared towards what might be effective for an appeal?
I don't think it's going to be effective because it sounds good, but his vocabulary is actually quite limited. And like when he's doing a cross-examination on a witness, he can't actually copy what the other side did. He's allowed to ask leading questions. Like, you don't have to say, what is your opinion on this? You can actually say, direct and leading questions like, isn't it true that on such and such day you did this? And he missed a number of opportunities where he tries to ask things the way that the other lawyers did, and he missed his opportunity to actually get a targeted response. And you mentioned that he had defense attorneys before, but remember that all the prep for those witnesses, much of that is work product. When you are no longer with an attorney, you get your file, but you don't get their work product. You don't get a lot of the, like the witness outlines or things they were going to ask. The defense attorneys might have said, here's all of our things. These are our questions. These are our whatever. that as an attorney, I do shorthand. I don't write every single question down.
And good luck going through so much shorthand.
No, you're not going to
be like reading a foreign language completely.
No, and it's a tree, because if someone gives one answer, you go one way, and if someone gives another answer, you have to be prepared. Sure. I don't think it's effective. I think I've actually been a little sad for him. I know it seems like he's getting a lot of attention from the judge, but to me, he seems like a child that put on his parents' clothing and walked into court, and he's going to pay the consequences of making that choice to represent himself.
I mean, this opening statement of his, when he came out and he was, started crying and pulling the crocodile tears, that for a moment I was like, but then I realized, like, no, it's theatrics. It's all theatrics. And then because you cut over to him building his little box fort, and he's, being just defiant as you can possibly be, and doing nothing but showcasing, I feel, the fact that he has zero remorse for what he's done. I think he feels in the course of his, well, let me not tell you what I think. Have you seen any red flags as an attorney that have popped up where you're like, uh-oh, that could be a potential, maybe something he could, if he knew more to hold on to? Yeah.
Just, he said he didn't have an opportunity to present his evidence. He did show a real lack of understanding of when that opportunity might have been. Mm-hmm. Although the judge explained it, he brought up, in the beginning, you told me it wasn't time for my evidence. And depending on how exculpatory that was, I don't know what his evidence is. His evidence was not presented to the jury. If it's actually exculpatory, like if it's evidence that if it had been presented would have exonerated him, then perhaps. But I highly doubt that anything he's holding, but for that information, the jury would have found different, or as a matter of law would have saved him in this case. I actually have to go. I'm headed to another hearing. But thank you very much for your time. Any other questions, I'd be happy to answer. Have a great day.
All right. Thank you. Take care. So yeah, that was a friend and attorney out of Houston, Texas, who has been practicing law for a while now, and definitely has a much better bearing and understanding as to what's going on in this case. I did not get a chance to ask all the questions that I wanted to ask. Obviously, she was but running right up against me. She has a meeting in 1 minute she has to get into. So as opposed to waiting until 2 o'clock when I think she's done with her meeting, which I believe they're coming back from lunch, and then they're going to go into closing arguments. So, I mean, if this is what we have to look forward to, Darrell Brooks and his full sad sack, please just have some pity on me form, then Lord have mercy on us all, because we're in for it. But I don't know if he's at that point anymore. I think at this point, the closing argument is just going to be for him to ask, he's going to ask the judge or the jury to just the case. Let me show you guys is no, right now where they're on lunch right now. So you guys know. Let me go this right here. I'm going to make sure you guys know what's going on. So court is at lunch. That's scrolling across the bottom there. And I'm not going to even try to say your last name because I would butcher it. So Darrell Brooks, we're in a place right now where this guy is, like she said, he thinks that he's litigating his case well. He thinks that he can do what he wants, when he wants, how he wants. And what I really wanted to dig into, and we'll bring her back on maybe later in the day or tomorrow. We'll definitely have her back on because it definitely has a lot of, and she's been following the case, so has some insight that I think a lot of us need. But one of the things that I'm really curious about is how this guy is been able to have as many outbursts. I mean, in any court of law, I know they're having to do what they can. Like she said, the judges had her hands tied in a big way with having to avoid mistrial and appeals and things where an actual proper defense attorney, like a good defense attorney, might have some fundamental understanding as to how to do that, right? What's funny is this little clip right here of Judge Schroeder that I play.
Pardon me?
That was before the
Don't get brazen with me.
That was from the Rittenhouse trial when Judge Schroeder was reprimanding the prosecution, the DA, for for the way they were presenting things and the line of questioning and some of the evidentiary findings, I suppose you'd say, that they were trying to bring in that they had already ruled out in the pretrial meetings they have with the attorneys. And these are things they go over. They go over the rules, basically. They go over, like the judge said, I'm the whatever you want to call it, the how did she say, the umpire, or the official. What did she say? One of those terms. I'll call it the umpire. I think she mentioned that once. But at the beginning of a fight, right, you have your referee, if you will, if you go that route, right? So you have someone in the fight that's keeping both sides aware of what the rules are. We know you're both coming out swinging, but here's what's going to be allowed. Here's what's not going to be allowed. Here's how I'm going to approach this. Here's where I'm going to be lenient. Here's where I'm not. I need you to understand that there's rules here. This is the decorum. This is what I expect from you. Moderator, referee. Yeah, referee. I was having a real tough time pulling out that name. I don't know why I was drawing blanks on that, but really what she's doing though is avoiding the appeal process. But what I wonder is, had an attorney in her same situation, had an attorney done these same things, yelled at a judge, or pounded on the desk, and how do you even call yourself a judge? I mean, those types of things blow my mind, because you would be held immediately in contempt, and he's pushing hard for a contempt charge. So when we have her back on, and again, I'm really grateful that she came on. I thank you for being a part of the stream today. You're awesome. And when you get back out of your meeting, hopefully hit me up. Let me know if you're available, and we'll bring you back on. Well, we could even bring you on. I know closing argument is going to be different, because that's not really one you want to narrate through. But it'd be nice to have an attorney on with us during some of the proceedings. And it's too bad we weren't able to do that earlier, but we're here now. So but I'm curious how that works out. What would a contempt charge do to this case? And so hopefully we'll find out more as we move forward. But closing arguments are coming up. But the outbursts, man, have been ridiculous. I'm amazed with the amount of leniency, and I get it. I mean, I get it to a degree. I think we all kind of understand to a certain degree why and what is happening, because we see his angles, we see what he's playing at. But I think we all understand that it's just not working for him. So what I want to do here for you guys, though, is pull up some of these clips of his outbursts, because it's really, I'm sure most of you in here have been watching. We're not into closing yet, so Anna Shy, we're not there yet. I promise you, I'm watching it. When they come back from lunch, at the bottom here, quarters at lunch, the closing arguments to follow. Here, let me make a bigger banner for you guys, so there's no questions about what we're doing right now. But sorry, it's kind of loud. I know. Sorry, Toad. I know that it's quarters at lunch. There we go. But I want to show you guys some of these Darrell Brooks moments that have been, and I know at this point we're getting close to having some serious highlight reels. I mean, some real gems of Darrell Brooks. And actually I have in here, I think if you can't see this, so these are the notes he's been writing, and you can't really read it. It says, you still have yet to prove subject matter jurisdiction. Can you? And then at the bottom it says, let me pull that up for you real quick, because these are some of the things that when he's having to do his objections, the judge is not allowing him to, basically to speak. She's got him muted, and in order to do so, in order to say anything, he has to write out his objection and then put it down. Let's see, the best interpreted this is an objection. This jurisdiction is read to recede. No objection. Okay, I can't read what the judge writes a response. So these are entered officially into into the court records. This next one here, which you can't see, so we're not going to worry about that. But I'll put this up here so you know that we're not missing anything. It says this was funny. This is while he was questioning, cross-examining one of the officers. He said, why is he looking at the jury while answering? They are not asking the question. And then he did his exclamation point instead of a question mark, whatever, with little bubble, almost damn near with a heart. I mean, sealed with a kiss. And then he says, how is this allowable for him to look at somebody else while he's answering my questions? He should have to look directly at me. I don't want him seeing anybody. The judge just simply wrote back, no response needed by the court. That's it. And then she signs her initials. See ya. So he sends his objection in on paper at 1:44. It's filed, stamped, and then the judge responds and sends it back to him at 1:52. So in 8 minutes, it goes from that whole process, from him holding up his objection signs, which is what he's been doing. He's had to stand there and hold up these signs, and as you see in the corner of I object. And then, but then they got him building box forts over there and stuff too. So he's over in his little courtroom, his little fort room, as we're calling it, building, building his forts of defense that he thinks will keep him from, people seeing him or knowing who he is. Who knows what his real thought process is on that? Because he's a crazy person. He's not crazy though. Let's not get that messed up. Not crazy. He's just an asshole. I mean, that's really kind of what it is. He's not crazy. He's really just a raging prick. So, which I can say without hesitation and the utmost confidence, because he is. Those are the facts of the matter. Those are the facts as I see them. So let's be clear about that. But we're going to pull up some Darrell Brooks moments here for you guys. Any questions that you have in the comments here for me that I might be able to answer? Fort Brooks, Ezekiel, I like that too. Yeah, Fort Brooks is good. That's yeah, Fort. Is that like Fort Bragg? It's Fort Brooks. Carol, thanks for those blessings, and you guys, thanks for the stars. Again, they keep the lights on, keep the camera running, keep this snoring puppy of mine fed. You guys, it makes a big difference. Actually, it makes all the difference. Illinois versus Allen, which I think gagging was one he thinks that will have grounds for the appeal. He was opted not to. So we'll look that up. That's one of the questions. Danelle, I'm going to go ahead and pin that so that we can come back to it, which is the Illinois versus Allen, which is one of the cases that the judge keeps reciting. And Darrell Brooks he's on this kick where he feels that, that's, not, that's what I'm hearing is the whoosh of the computer. My bad, you guys. I'm going to put this. He feels that he's not getting the treatment he deserves, but she's letting him know that what you're getting is exactly what you get under the proper delegations of the law. Fort Brooks, yeah, that's good. That's good. Anyway, so this was just, I mean, we've been watching today. So he was talking this morning. He was already this morning talking about how they were prejudicing his rights, his defense, and it's crazy that here. Well, I'll show you guys that real fast because for me, from what I've seen, I can't imagine her having been more exhaustive in her efforts and attempts to be as, obliging as she's had to be. Yeah, he's guilty as hell. Yeah, guilty AF, no questions. We all know he's guilty. He knows he's guilty. His goal is to get motions for an appeal moving forward, and that's what we'll talk to our attorney friend hereafter and get her input on things.
When you tell me
this is earlier today,
this is what you need to do, I'm gonna take it by what you're telling me.
And this is when she was saying this is the process.
If I needed to make anything request wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence. You told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things in the evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense. Things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr.
that
Brooks,
things
I'm gonna
that
cut you off
clearly help my
because
defense.
Good question,
I stand
Shirley.
by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record, your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr.
We're not going to have to sit through all of it, guys. But so Darrell Brooks is, he's saying that, I'm doing everything you're saying I'm supposed to do. I'm doing it by the book, and I'm being respectful. I'm being, and it's wild because you've been watching. I was dying laughing while he's saying it. I'm like, you have done nothing you've been told to do. You made it a point that you won't be told to do. I'll show you a clip where he's, you're not going to tell me what to do. I'm a grown man. I am a grown man. It just blows my mind. And then he says at one point, he says, I don't understand anything, Your Honor. And she says, well, how did she word it? I can't object to that. Or I agree to that. And I mean, she wasn't talking about that statement, but ipso facto, right? It's a court term. Someone put the meaning up in here. Ipso facto. I actually don't know what that means. It just fit. I think it means that all things come to the same conclusion. My legal folks put up ipso facto. Illinois versus Allen. Here we go. See, Caitlin says Illinois versus Allen is the reason she used a timer. He refused decorum. If he tries to fight the judge's decision, she has done enough to secure the same outcome as Illinois versus Allen when heard by the Supreme Court. Your rights were given and your choices were respected according to law. So yeah, she makes it a point to ask, do you understand? 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 And in that process, she finally gets to a point with, we've seen it 90% of the time, is she says, I will accept your lack of a yes or no as a yes and move on. And then once she says that, boom, I didn't agree to that. I don't understand that. Okay, explain. I still don't understand. And then he says, I don't understand anything. Well, that's obvious. Obviously he wants us to believe, or her to believe, would love it to be the case where he really truly doesn't understand. But this is where I have questions for our attorney friend as well, is when you choose to represent yourself, are you still able to use the same argument that you would have used had you been a defendant being represented by an attorney? Because if an attorney doesn't represent you properly, you can always say that you weren't given a fair trial because your attorney dropped the ball, and go for an appeal there. And another attorney can come in and say, hey, you're right, this wasn't done right. I'm going to pick this apart because of this court statute, this. You do have grounds for, an appeal, and we're going to work that angle. But once you remove that buffer, now you're saying, okay, I'm taking the risk now. You've taken the training wheels off. You're like, I'm going to ride this bike on my own, and while he's doing that, he's saying, like, I've got this because I'm working a different angle. Well, you're putting all your eggs in one basket, because if that angle doesn't work, you're shot out. I was watching this cooking show last night for a little bit, and they have to do these cooking challenges on the fly, and they have to pivot, right? And and so this one guy's doing this thing, and it failed. The eggs broke, whatever, yada yada. So he has to pivot, right? He's like, oh, I'm going to do something different, and he pivots into like the crappiest thing he could have done, right? Like a popcorn dish, whatever. And that's kind of what he's doing here. Is he doesn't understand enough how to make it happen effectively in the first place, and so his pivot is even worse. And he's tried to do that so many times though so far. He's just tried to like spin it around, and he knows he doesn't have grounds in that. So what he's been doing is basically just trying to convolute and dissect a statement as he's questioning. He doesn't do anything towards positioning, right? Like we've seen this. He's done nothing towards gearing himself in one cohesive direction. He's done an amazing job of utilizing what he only has. And what I was saying was, our attorney friend was that those boxes may not be the notes and the direction and the outline, the grid for how to defend this case, the best way to do this. The attorneys probably said, you know what, bet you're done. You're doing it on your own. I'm going to go ahead and head out. I got coffee to get to. I got kids to go home to. I don't want to deal with you. You're the last person on the planet I want to sit next to. You are a monster of a human being. And, you smell like cheese. I don't know. But that's how they can deal with him now that they're gone. And now he has to deal with what's left behind, which maybe, if nothing more than what they left, is those boxes are just the reports, the reports. That's the evidence and reports that's being entered into the case by the prosecution. And then he's trying to figure out how to work with it. So you see him throughout his questioning, his lines of questioning, he's sitting there reading a report. So you said you heard a honk of a horn. And then you'll watch him like, how could I ask a question about honking a horn? If someone honks a horn, that must mean that they didn't want to hit you. They wanted you to move, but you didn't move. So it's your fault type thing. And then he starts playing on these little angles, but he has like in every witness, he tries to play a different defense card. You know what I mean? There's no cohesion to his plan. And so he pivots and pivots and pivots and pivots. And it's to a point where the prosecution even was laughing. At one point, I'm going to play a video for him. I'm going to try to find it. When he said, are there any facts that can you remember anything that you don't recall? And the jury or the whole courtroom starts laughing at him because he was saying that the witness is being coached. And he's like, was there anything else that you don't recall? And immediately the prosecution's like, objection. How are you supposed to remember something you don't remember? How do you recall something you don't recall? And he's like, well, I don't like you laughing at me. I think it was a good question for me to ask because it feels good to ask. And you guys are being mean. And I don't like the gestures you're making. They're being rude. He's saying things that's very rude and I don't like it. And it's just like, nobody cares. Anyway, this is him being interviewed. This is after he was arrested. So he's in court or in jail after he's being held at this point. And so I'm gonna take a look at and what he says here is I believe he says like my life is over is how he words it. So
a lot of people got hurt. Yeah. Are you serious? Yeah.
New evidence coming to light in the trial of Darrell Brooks. What happened in the moments after he was taken into custody? That is our big story tonight at 9, a different story than what the evidence presented. That's how police describe Darrell Brooks' account of what happened the night he's accused of killing 6 and injuring more than 60 others at the Waukesha Christmas Parade last year.
Sam Kramer joins us live in Waukesha, and Sam Brooks told police he was there to watch
the
Packers game with a friend.
He was arrested.
Yeah, that's right. Hi there, Ben. When police tried to connect the dots, the detective who questioned Brooks said they just didn't add up. Tonight, for the first time, we saw a video of that interrogation, which happened the day after the parade attack. We also heard what sounds like an admission of guilt.
Whose car did you drive out here? I didn't drive at all.
Inside an interrogation room at the Muskego Police Department, Detective Jay Carpenter pressed Darrell Brooks for answers the day after the Waukesha Christmas Parade attack.
How did you end up at a random house without your shoes and your phone, Darrell? This is what I'm saying. I had my flip-flops on.
But on the stand and in the recorded interview shown to the jury Tuesday, Carpenter says he knew Brooks' answers were lies.
For yourself, for your family, You know what happened yesterday for the people. Tell me what happened. Well, what? With the car.
Carpenter testified he attempted to build rapport with Brooks, first trying to question him the night of the attack related to loitering. But when police gathered more information the next day, his tone and line of questioning changed. Seen here trying to show video of what happened to Brooks.
Any reason why you were being so forceful in trying to do that?
Well, I felt it was very important for you to see the damage that was caused from the incident.
Police had already found the key to the red Ford Escape in his pocket and tracked ownership of the SUV back to Brooks' mother, Dawn Woods. After police showed Brooks video of the attack, he had this to say.
I understand my life is over. I'm trying to come to grips with that. I'm trying to come to grips with the fact that this is how my story ends.
This is how my story ends. My life is over. This is how my story ends. Why are you in the questioning, man? You guys have to go back and watch. I'll post. I tell you what. I'll post the interrogation on my YouTube page. It's CJTV Media LLC over on YouTube, so you can watch the whole thing again. But he's right there. He's saying like, I'm cooked. He knows then he's cooked. So from that point to now, he's decided that somehow he's gonna swag his way through this, you know. But you know, here, this is where we're at with him.
I'm trying to come to grips with the fact that this is how my story ends.
Now, prosecutors plan to end their story, their case of what happened tomorrow after the jury sees that Ford Escape up close. Then Brooks will have the option to make his opening statement and call more witnesses. He actually called his first witness today out of order, but the man who was injured in the parade did very little to actually give Brooks any sort of ground in defense in this case. We're live tonight in Waukesha. Sam Kramer, Fox 6 News.
Yeah, we still don't know what his defense strategy is, so we'll see in the coming days. Sam, thanks. Stay with Fox 6 for the latest from the trial. We're streaming the trial on Fox 6 News on our YouTube page and our Facebook page, as well as our website, fox6now.com.
That's Darrell Brooks right there. You know, even he in that moment, you know, it's this guy knowing that moment that he's cooked. You know, my life is over. I'm trying to come to grips with that. You know, well, what he needed to come to grips with is the fact that he just ended 5 lives and a 6th to follow, which was an 8-year-old little boy who died the next day. So that's where he is at in his realization. I think now he's more than ever realizing that, even though he's playing this card, you know, building, you know, he's in his, you know, fort room where he's playing, you know, army soldier, whatever he thinks he's doing. But the Detective Carter, when he that was actually the detective was good. That was a good interview. I mean, he wasn't putting up with anything. Here, I'll pull it up for you real fast here too, so you guys. Because this is the one who initially interviewed Darrell Brooks when he was arrested, and then he was asking him, you know, he's like, "Why are you being so forceful? You know, what are you going for?" And he was like, "Listen, man." At one point, I'll show you this too. He's finally just said, "Listen, you're lying. We know you're lying. I know you're lying. This is where you're lying." And he shows him, and that's when he starts clicking, like, "Oh, damn, I can't poke holes in this right now. You know, you guys are seeing through me, and so what am I going to do?" And you know. And so let me play this one for you guys here. It's a quick clip of the detective just kind of having enough. You know what I mean? He was just like, I'm over you, you know, being such an asshat.
Standard procedure to not tell a person why they're being detained?
Well, we didn't not tell you. That's incorrect, and it's misleading to the court. You were informed you were being detained for prowling, loitering, disorderly conduct of that nature.
Is that the same as?
Can I finish, please? I just didn't bring up the parade part of it.
Why not?
As I stated in earlier testimony, it was very fluid and chaotic, and a lot of information wasn't yet known. So I was waiting to receive more information.
Did you state in your early testimony if that was standard procedure or not?
It's standard.
So with every detainee that you've ever detained during your career, 18 years, right?
Yes.
It's standard procedure to not tell someone being detained what they're detained for.
As I had stated in my earlier testimony, Mr. Brooks, I explained to you were detained for prowling and loitering and disorderly conduct. Based on the lack of information on the parade, that was not brought up. So what I can clarify for the court at this point is that in situations where so limited information exists early on, it is standard not to convey that information to suspects.
And what do you mean by it's standard?
I mean that I don't tell them because I don't have all the facts yet, and I'm not looking to necessarily accuse them before I know the nature of what they did or didn't do exactly pertaining to that incident.
Right. So
And just for the
that being said, Darrell Brooks again he's hoping he can poke a hole in, even in the detective's testimony. Excuse me. And don't worry, I'm keeping track on. We're in there. Sorry. Okay, now we're better. I did some tasty coffee. Here's another one for you guys. This one, even the witness looks at the judge and is like, how do I field this question, Judge? This guy is, he's a clown, and it's wild that there have been so many of these. Like it seems like every witness that is called has to go through a moment of Darrell Brooksisms where they're like, that question makes no sense in their head. And they're like, could you ask the question? And even they're like, could you ask that in a different way? Or they'll flat out say, I don't understand what you're saying, and then he'll repeat it the exact same way. What he does with the witnesses is it's comical. The way he handles it is the way you see it in like skit comedy, when you see somebody trying to talk to someone in a foreign that doesn't speak their language, like in a foreign language, and they like, do you know where the train station is? And the guy's like, no habla inglés, whatever. Do you know where the train station is? Like, I'm going to put my emphasis on a different syllable, and maybe that'll make sense to you. That's all he's doing, and he's hoping that somehow they're going to grab some kind of info out of that. But this one is
after he drove the SUV through the parade, I was called at home.
Who's he?
To come in and help the departments.
Yeah, the GoFundMe was taken down. He had a $5 million GoFundMe.
And just so we clear for the record, is the jury asking you questions or me?
Watch, you listen to the judge. Right?
Hear the question.
Even the TA is like, what are you talking about, man?
Well, I was referring to when I ask a question, he turns towards the jury as if they're the ones asking the question.
He still wants to control the power. Like, you have to look at me.
It is a question.
We did ask a question about that.
Yes.
I think you're asking, why does he do that to that extent of what you're saying?
Yeah.
I'm here to present the case to the jury.
So I follow that fundamentally.
But in reality, not so much, because I am a complete
for the sake of making sure you hear the questions right, wouldn't it be fair to say that you should pay attention to the questions being answered, or being asked, rather?
Assumes the fact, not evidence. Sustained as to the form of the question. Please rephrase.
Wouldn't it make sense to focus on the questions so you can hear them clearly?
Objection argumentative still assumes the fact, not evidence. Sustained.
You made reference to you being here to present the case to the jury. So is that the reason why you decided to testify?
Objection to the relevance?
Grounds.
Overrule, the witness may answer.
I don't understand your question.
Were you able to hear my question clearly?
I don't understand your question.
Were you able to hear my question clearly?
Objection argumentative, Your Honor.
Sustained. Next question, please. Or rephrase the previous question to the one that was asked just now.
What was not understood about the question that you were asked?
Objection
The question.
Grounds.
Oh man.
Sustained.
Nikki, thank you.
That's the form of the question. Please rephrase.
What wasn't clear about what I was asking?
Same objection, Your Honor.
Grounds.
Carol, are you asking me if I'm a Leo? No,
It's
I'm not.
the objection is sustained. Let's
Though in the
back
stream
and
world,
ask
that
the
was always
question.
controversy. Like maybe
says he didn't understand.
CJ's an
and
undercover cop.
Rephrase it, please, or move on. Your choice.
Was your sole reason for testifying here today?
Objection relevance.
Let's let Mr. Brooks get the question out.
You don't even want to hear the rest of the question. You watch it.
Apologize. I thought that was it.
No, you didn't.
Are you testifying today strictly to prove your case to the jury?
Objection misstatement of his testimony.
Grounds that's what he said.
She says the grounds. I love that his objections.
Sustained as to the form of the question misstates the prior testimony.
They're the grounds for the objection.
He said.
That's what he said. I'm just saying what he said.
So why did you decide to testify here today?
Oh man.
Objection. That's a legally inaccurate question, Your Honor.
Please rephrase the
Or as
question,
Darrell Brooks would say,
sustaining
the lawful
the
law.
question asked as to the form of the question.
Oh, Donnell Payne. Okay, cool.
I don't know how I'm supposed to rephrase that.
Well, whose fault is that, pal? Rephrase that? Dude, I want to go as Darrell Brooks for Halloween just so people can get some,
Having
like
the same
punch
form
me
of
if they
question.
want. No, I don't.
That helps.
Who?
A rule if there's an objection.
It doesn't help you.
That's the question.
That's for sure.
Did you seek to testify here today in this matter?
Court is at lunch, Terry. They'll be back for final arguments after, closing arguments afterwards.
So how did you ultimately come to that decision?
Objection. That's a misstatement, Your Honor. It was not his decision.
Sustained as to the form of the question.
It's the law.
Were you subpoenaed?
Yes.
That's how it works.
Do you recall by whom you were subpoenaed to testify?
District Attorney Sue Opper from the Waukesha County District Attorney's Office.
And at that time you were subpoenaed, you decided to testify.
I don't believe it's my decision.
Nope, it's not your decision. That's the thing. That's the law. You get called to testify. You're there to testify. Here's an interesting thing I pulled up here. So we were trying to figure out. I was curious about Illinois versus Allen, and what that case study was all about, which held one. Okay, so actually, no, I have a little video. Let's watch this real quick. I'm going to add this to the stream here, and we'll go ahead and let the simplicity of this described through the art of cartoon reproduction. Yeah, he did. Stephen MC asked, did he have a $5 million GoFundMe? When Darrell Brooks was arrested, there was a $5 million bail GoFundMe that was posted. I don't know how quick it was taken down. Pamela, what's up from Geneva? But it was taken down. It was definitely removed. Yeah, didn't last long. $5 million. They thought someone was going to. It could have been a money grab, though. You know what I mean? It could have been just them trying to grab somebody saying, hey, man, we'll put it up. There'll be enough people that are ignorant of the case that'll throw money like, oh, man, it's another man that's being tried for a crime he didn't commit. We'll go ahead and throw a couple bucks his way. You know what I mean? So, but it was definitely shut down. So this is the Illinois versus Allen. which is yeah, I'll go ahead small here. So I know you guys can't read all this, but it's basically they're saying Allen, the defendant, was a defendant in a criminal trial. Despite repeated warnings from the judge, Allen was highly disruptive and antagonistic. The judge ordered Allen's removal so the trial could be conducted outside his presence, but later allowed Allen to return. When Allen resumed, unruly, you know what? We're just going to watch this. How about that? Let's do that.
A criminal defendant has a right to be present during his trial under the Sixth Amendment's Confrontation Clause. But may a trial court remove the defendant from the courtroom and continue with the trial in his absence if he repeatedly engages in disruptive behavior? The United States Supreme Court addressed this issue in Illinois versus Allen. William Allen was charged in state court with armed robbery. The trial court granted Allen's request to represent himself, but appointed standby counsel. During jury selection, after Allen began arguing with the judge in a highly disrespectful manner, the judge asked standby counsel to proceed with the voir dire. Allen responded with a death threat to the judge. He also ripped standby counsel's file in half and threw the torn papers on the floor.
Darrell Brooks has done that.
The judge warned Allen that if he engaged in any more disruptive behavior, he would be removed from the courtroom and the trial would continue in his absence. Undeterred by the judge's warning, Allen declared his intention to continue being disruptive and made more disrespectful comments to the judge. The judge then ordered Allen's removal and the jury selection proceeded in his absence. After the jury was empaneled, the judge advised Allen that he could return for the trial if he stopped being disruptive. Allen returned to the courtroom, but he soon angrily announced his intention to talk throughout the trial. The judge again ordered Allen's removal from the courtroom. After the prosecution rested its case in chief, the judge again told Allen that he could return to the courtroom if he behaved. Allen returned for the defense's case, which was conducted by the standby counsel. The jury convicted Allen. On Allen's direct appeal, the Illinois Supreme Court affirmed his conviction. Thereafter, Allen filed a federal habeas corpus petition challenging his conviction on the ground that the trial court's removal of him from the courtroom had violated the Sixth Amendment's Confrontation Clause. The federal district court denied the petition. The United States Court of Appeals for the Seventh Circuit reversed the district court's judgment, ruling that the constitutional right to be present during trial is absolute. The Court of Appeals held that the only recourse for a trial court is to restrain a disruptive defendant with shackles and a gag. The state successfully petitioned the United States Supreme Court to review Allen's case.
That's Illinois versus Allen. A little bit of an explanation there as to what they're talking about with what he keeps bringing. They keep bringing that up. The judge keeps bringing that up. This is based off Illinois versus Allen, which is we can have you removed. And she keeps saying, if you give us an oath or a pledge that you will actually act right, if you'll act right, we'll bring you back. But she wants him to give a written oath, which is wild because he's made it very clear. You can't tell me anything. I'm a grown man. And are you asking me or are you telling me? He keeps doing that. Are you asking me or are you telling me? Mind you guys, court is at lunch right now. When they come back, we're going into closing arguments. So please share the stream, you guys. We're going to keep doing some video review right now that is helping to explain better what we've been watching. So share the stream out, you guys. Closing arguments are coming up. That's important. But he's been claiming to be sovereign, right? So here we go. Let's take a look at what it is to be a sovereign citizen. I haven't seen this particular video yet, so I apologize if it's offensive. Okay, and actually this is a direct link to the Portland Red House, which if you guys don't remember, they tried setting up another sovereign nation down in Portland, much like the Occupied protest, the CHOP, the Chaz, the Capitol Hill Autonomous Zone, the Capitol Hill Occupied protest, whatever you want to call it, where I started my streaming back in the day, just as CJ, just out there with my camera recording and a microphone with my cousin, interviewing people. But So they're explaining what a sovereign citizen movement is. And so the quick Wikipedia explanation is a sovereign citizen movement is a loose grouping of litigants, activists, tax protesters, financial scheme promoters, and conspiracy theorists who claim to be answerable only to their particular. Well, I'm just gonna let them explain it. How about that? We'll do that one. I feel like it might be a better solution for us than listening to me having to read through stuff that we can have somebody else explain, and you don't have to listen to my voice anymore. I'm okay with that. Hope you are too. All right, so boom, here we go. Boom. Again, like I said, I haven't seen this video yet, so we'll figure this out together.
According to the Southern Poverty Law Center, sovereign citizens believe that they, not judges, juries, or law enforcement, get to decide which laws to follow and which to ignore, and they don't think they should have to pay taxes. As Portland sociologist Randy Blazak explains, while there is a large section of Black sovereign citizens, the movement is actually rooted in racism.
I mean, the sovereign citizen movement really starts within the white supremacist movement. It starts as kind of an anti-government belief system that white people are the true citizens of this country. It's kind of a weird reading of the 14th Amendment, and it believes that there is no real authority of government other than what they call common law.
Sovereign citizens are known for clogging up court systems with hundreds or thousands of legal filings. The filings are written in a nonsensical sovereign code, which most people can't understand. For years, they used that method to fight paying taxes, then as a way to fight foreclosures.
A thing that happens in the 2000s when the mortgage crisis happens, when the predatory lending that really targets Black and brown Americans starts gaining speed, and those folks start hearing about this notion that government law is not valid, mortgage laws are not valid, they can't take your home away from you. And so there starts to be this kind of in-migration of African Americans, especially into the sovereign citizens movement, to see it as a way of keeping their homes.
Christine Sarteski, a professor at Chatham University in Pittsburgh, just wrote a book on sovereign citizens, said a subgroup called Moorish sovereigns are known for fighting foreclosures this way.
And they have, they operate similarly, but they have a different origin belief. That basically they were originally here before anyone else in the United States or anywhere, and they essentially own all the land.
So how does the sovereign citizen movement tie into the Red House situation in Portland?
I am an Aboriginal indigenous to the land.
William Kinney III, seen here in a YouTube video, is the son of the family at the center of the Red House drama and encampment. He has.
If you guys don't remember this was, like I said, they were getting an eviction notice, and they had the troops rallied. You know what I mean? The like Antifa and all these folks, like they rallied up, and they built perimeters. They had like explosives. They had all sorts of crazy stuff. They built this perimeter on the whole block. And these are other houses that got sucked into this too, but they were claiming that, you know, the sovereignty of it. And so this is how it applies to that Red House in Portland. This is back, I think this is 2020. I mean, like all part of that, the tail end of 2020, if I remember right.
Claimed to be a Moorish sovereign citizen since at least 2007. In 2018, his parents lost their home to foreclosure, and Kinney, who changed his name to William X. Nietzsche, tried to fight the foreclosure in court, filing dozens of appeals. He talks about this extensively in the YouTube video.
They have used this kangaroo court to try to eject my elderly mother and father from their land on 20, 30 occasions.
The video gets confusing. He tries to seize the court under Moroccan law with a man named Omari Jibbery.
All right, they had me as a John Doe. Right there, I had to play dead for 20 seconds. All right, just to get some breath back and yell my name, Emperor Omari Jibbery, Emperor Omari Jibbery. But they already cut up my clothes. They thought I was dead.
The video and court filings are hard to follow.
Does this ever work?
When it works, it's usually on small little government fees that they can argue, and usually just through filing a petition after petition, where the local official just gets tired of them and waives the fee. On lower level things like that, it's been somewhat effective, which gives them an idea that this isn't actually an effective strategy. But on mortgage, it's never worked. Banks are powerful institutions. They often have the last word on these matters.
Which is what happened here. William's argument did not work. The family missed a series of payments. The home was foreclosed on in 2018, and the Kinney family was ordered out in September. They refused to leave to this day.
Okay, Kristen Severance, really quickly, just to make sure I understand this the right way. At the end of the day, they don't believe that the rules, the laws apply to them.
That is the crux of the entire, sovereign citizen defense when it comes to foreclosure cases, when it comes to really anything, that they don't have to follow laws.
But at the end of the day, they do.
They do. And that's why both of the experts I interviewed today said that this defense, especially when it comes to trying to fight a foreclosure, has never worked.
Got it. Okay, Kristen, thank you.
Yeah, so that's as it is, that's the breakdown for some of what it means to be sovereign. Court should be back. When is court going to be back? Good question. In the comments, you guys want to throw that up here? I don't know if they were doing a 90-minute or a 1-hour courtroom lunch, but that's a sovereign citizen explanation for us. And it doesn't explain much. It just is almost as confusing as anything, because all it's really doing is saying that you're not allowed to tell me anything that I don't want to hear, because I don't want you to have rules that I have to follow. So, and I don't understand, the Moorish aspect of it. But anyway, we're going to look at more Darrell Brooks videos here, because there are so many. And then before we go to closing arguments, I want to show you his opening statement, which, if you guys don't remember, it's man, it was rough to watch, because you just really, it's impossible not to be furious at this guy. And then you see him up there trying to play the emotion card, and it makes me, more than anything, want to drop kick him in his femur. You know what I mean? Because it's just in 10 minutes, they say. So, okay, so they're back at 2 p.m. Cool, 2 p.m. Let's see, we got, since we got a few minutes left here, this one was wild. When he was screaming about it being a joke, this is just 4 days ago, when he was telling the judge that she doesn't understand, he doesn't think it's funny, and your life is not on the line. And there's been so many from the beginning, though. This is here. Let's pull this one up for you guys. And we might have to skip through it a little bit, but it's something we can take a look at for a few minutes while we're waiting for court to jump back in here in the next 10 minutes. But
regarding cross-examination, so the objections were by the state. One had to do with there was questioning about possible testimony with his niece and nephew, and then the jail cell search issues. So Mr. Brooks, you asked the questions. The state had objected. Since you're the proponent of what would presumably come in through the testimony of Detective Casey, what is your offer of proof as to why I should allow Detective Casey to come back on the stand and testify about his interaction, I believe it was with your mom, and possible testimony of your niece and nephew?
It don't matter with Detective Casey. He's off the stand. He's not going back on the stand.
No, but I told you I would recall him. I wanted to take it up outside the presence of the jury.
How do I supposed to know?
So are you withdrawing that, sir?
How am I supposed to know? I think I deserve a chance to rebut what was just said. I think I deserve that much if it's a fair trial.
What information do you want to provide to me about that last exhibit?
About what last exhibit? I'm talking about the audacity of the prosecution to just put that on the record when it's stated it's untrue.
I don't know what you're talking about. What's untrue?
We just heard her talk for 5-10 minutes straight. Now don't nobody know what I'm talking about.
I don't
There
know
was a reference made
specifically
to
what you're
there was
talking
a
about,
reference
sir.
made to what I'm supposed to know about the evidence stacking up and this and that, as if that has any bearing on what I still think and what I'm still going to present. It doesn't.
Well, that's not what we're talking about at the moment. I made a ruling on an
She's
exhibit.
been laughing and making comments under her breath the whole time during the whole trial, and I never said nothing.
You are the epitome of
but I can
under your
tell that
breath
it's directed towards me. I'm not an idiot.
I
And for her to sit there-
haven't made any of those observations,
I didn't
sir.
say
What
you.
I've observed,
I didn't say you, Your Honor.
No.
He said, I'm not an idiot. And she says, I haven't made any of those observations. I think maybe she's super on another level. And what she's saying is, I haven't observed you not being an idiot. Oh, just saying.
What I've observed is
listen, please.
Go ahead.
Listen, please. But he shuts her up and says, listen, to a judge. Whew.
For her to sit there and try to play it off as if she's not referencing to me, she must think I'm an idiot. That is very disrespectful to me. I haven't said anything about that until today. She's done it numerous times.
What are you talking about? I don't
Her
know.
laughing under her breath. Her trying to cover up the microphone so they can laugh and he and key. That they be doing that the whole time.
Damn.
I didn't say anything. I didn't say anything about it.
I have not noticed that. What I notice are 3 attorneys who cover up the microphone so that they're not heard when they're conferring with each other about evidentiary issues or about testimony.
So why is it always laughing and giggling?
I haven't noticed that other than the one thing you pointed out.
All right, guys, I believe that we are back in. I think they jumped back in a little early. So share the stream, you guys. We're going back in. We're going back in. And we're moving into closing arguments. So this is, I think they still have it muted on their end. So we didn't quite get a chance to do what I was hoping we were going to do, which was listening to the opening statements. This could just be him sitting there as well. You know, it could just be him killing time. So until they come back in, I'm going to go ahead and I'm going to play this a little longer here. Just because it's in. You know what? No, we have a few minutes here. Let me. I got you here. That you guys keep watching this. So that's Darrell Brooks. Not a frozen screen. It's actually him doing what he's doing, and we'll get what we can out of this before we go any further. And here we go. Don't worry, I'm going to keep tabs on it, though, so I know we're going to jump back in when we need to get back in there. But before closing arguments, I would love to see you guys. If you didn't get a chance to see, this is Darrell Brooks' emotional opening statement.
The defendant will now make an opening statement. The purpose of an opening statement is to give the defendant an opportunity
Let's do this. Here.
To tell you what he introduced are not.
Obviously, I don't have any.
I don't know why it's obvious.
Well-prepared speech, so I'm just going to speak from the heart. I would just like to first say that I want to bring to remembrance something I think everyone in this room has been taught pretty much as far back as we can remember.
Doing to others?
Is that there's always 2 sides to every story.
Actually, there's 3 sides: yours, mine, and the truth. So,
and for so long now,
yeah, they're not back yet.
A year. There's only truly been one side told of this story, and
no, this is his opening statements.
I've sat back and watched from countless narratives that's been put out there.
Court is at lunch. It'll be back in just a minute. They have the video up but no audio.
Portrayed at times, and finally, everyone getting a chance to get the full story. You won't hear me try to argue facts. The fact is that this incident was tragic, very tragic. That's not lost on me. Facts are that there's still a lot of people healing, a lot of families healing on both sides. And when I'm confident that the evidence will show, I'm sorry, I'm getting a little emotional. When I'm confident that the evidence will show is that this incident was not planned. This incident was not intentional.
Thank you, Matthew.
This incident was never even thought about.
Nope, you really didn't think, did you? Not a defense. Steve, there's no riots happening in the streets on this guy.
I'm sorry. Just need a second.
This is where he turns it up, you guys. This is where he turns it up a notch. And what I can do here for you is I can give you an audio here. I can give you a split screen, so you can see him right now. So you know we're not going to miss anything. And then I can give you the this because I got audio on both. I'm trust me, I'm listening. I'm watching. So yeah. Court's not back yet, though, guys. Work on it. Bite your tongue. Bite your lip. Oh, wow. Just the wow. Oh, I wish you guys could see. There's a side-by-side. Oh, well. Court's not in session yet. He just did the same face. But they're not doing court yet, so we'll be back in a minute. Hey, what's up, Dave?
I think it's
There you go, Beverly.
It's easy to look at the magnitude of something like this and form opinions.
So the judges come in. They're still not quite back up yet. So
I think it's easy to disregard a lot of factors.
yeah, they're still not back in yet. They haven't gone live yet. They're just settling back in.
In reference to what I stated earlier, it's
Thank you,
easy
Tamara.
to forget the other side of the coin.
They're coming back in 2 seconds here.
There's been
Okay, we're gonna go back into. I don't want to miss out on anything here for you guys. I know that people really want y'all want to get it right away. So,
and Propria persona. This is a military admiralty tribunal and maritime law.
that's a sovereign
for
thing.
United States Code Section 1, which you can see, which states placing a fringe on a national flag is within discretion of the president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising, as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, what has yet to be proven on the record.
For truthfulness or untruthfulness, it's not specific instances of character evidence, which frankly wouldn't even come from the witness. All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that.
Is that better, guys?
I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's.
I accept the value in return for value of this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? Well, I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments or the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Opper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
It's going to put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long as
I was going to put it like right about here so that he could still see me and the jury.
With that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask to object and ask what it is that's actually.
You guys, that's as loud as it gets.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing argument.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I guess it
exhibits?
depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break.
Yeah, that's as
depending on
loud
what
as it's going to
it
get,
is.
guys. Sorry.
And if there's something in particular, you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state had.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues.
this guy.
The court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific. My other filings that
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused
asking, are you done?
Which you keep saying that's rude. Yeah, he's a rude
Your Honor,
asshole.
how come every time I try, even when I try to err on the side of caution, you find some way to
You're
make
not
it
erring on the side of
to be
caution.
something
You're being a
that it's
prick,
not?
dude.
I didn't know if you was gonna say something else.
Yeah, you did.
I've asked a question, sir. So when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir. So I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
explain
you are
why
not
that's
going
not
to
relevant?
be able to raise those
That's just the way
types
the
of
law works,
issues and
man.
present a
That's how it
closing
works.
argument based upon my oath of office,
Man.
whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction to
So
you.
they can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
So it's
not?
not relevant to the determinations of guilt or innocence in this
It's the
case.
truth.
Mr. Brooks, your custodial status is not on trial here.
I will
No,
argue that it
your
is.
conduct from November 21st of 2021 is what
That
is on
hasn't been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which
you
I
are-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr.
Amendment
Brooks,
right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct
land.
your attention to closing instruction 460.
I'm
which
going.
will be
I'm
read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't. No state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows. And that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding
How
your
long will he
appeal.
last?
It's
When the
not-
jury comes
I am
out,
not
allowed to
required
make
to
the
give
record
you
at
that
all, Your Honor.
opportunity, sir.
I'm not allowed
Sir.
to make the record at all.
Put in your votes, people. Put in your votes. How long is he going to
As
make
I
it
just
before he
let
gets
you
kicked
get,
out
because some-
when the
some
jury
of the
comes
issues
in?
I
has
have-
been-
He didn't make it
some
1
of the
second
issues
last
Tell
has
me
time.
what
been-
you want to do. I
Your
told
Honor.
you you can't.
your votes
I've
in.
addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and is unlawful law. You haven't shown one time that is lawful for you to do what you've
Unlawful
been
law.
doing as
Mr.
far
Brooks,
as your rulings.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make
Honor.
an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every
Now he's
issue.
interrupting. Sit tight, guys. I'm not sure what's going on here, but we should be running back up here in 2 seconds.
More than 300 murders just last year. But defund the police radical Mandela Barnes still supports no cash bail.
Reducing prison population.
Okay. Well, we're back in, but I got you guys here. Sorry about that. I'm not sure what was going on with the. There we go. Sorry, guys. We're back. Don't go anywhere. Don't go anywhere. And we're gonna go ahead and add this stream. There we go. Boom. So yeah, I'm having a buffer issue for a brief moment here, but yeah, bear with me, guys. Bear with me. Let's get out. Well, this is unfortuitous, if you will, if that's it's an unlawful law buffer. Yeah. Give it 1 sec. Court is having an issue. It's not on my end. I'm going to say that. Yeah. We'll fix this right now. We'll get this all fixed up. Don't go anywhere, guys. It'll be back up in 2 seconds here. Okay, here we go. We're back. We're good. People are jumping ship. Don't do that. There we go. And here we go, guys. I apologize for the... Mm-hmm. Okay.
Issues from my perspective.
There we go.
That is
Sorry, guys. We're back in.
Simply
How am I being in
delay what we're
dishonor?
doing.
How am I
So
being
you
in
are put
dishonor?
on notice. I am done dealing
How
with
am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going to
preserved my
address
rights?
this
John.
further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt.
Share the
by
stream, people,
Illinois
if you would,
versus
please.
Allen.
Sorry.
You can do that.
Lost some folks here.
You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments.
Apparently
but
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was it is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir. And
or I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say. But I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is
not-
a whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still,
I need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that I
you
don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to
preserved.
have the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be
And
held
when
in
this door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now, because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will forfeit
and I
your right
expect
to
for
be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
How long is it going to last?
Take me to the next courtroom.
How long
Please,
is it even going to
take me
last?
the next courtroom.
Is it going to make it through 1
Hold me
second?
in contempt.
How
Hold
long?
me in contempt. Hold me in contempt. Hold me in contempt.
She's going to walk down there and slap him.
I have constitutional rights that are being trampled on, and you're coming up
hear
with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity.
He's not going to make it.
Of the court's rulings, whether he agrees with them or
He's
not.
not going to make it.
I'm merely exercising my rights under the Constitution, under the First Amendment, under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way that you have
disrupting
through
the
the course
proceeding.
of
You just
3
told
weeks.
me you don't have to honor my constitutional rights in so many words.
Tase him.
You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
What's the
you
business?
that the
What the
jury is
business? What's the
outside the
respectful
door.
of their
business?
time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful
not
of
gonna
the
make
court's ruling,
They're
whether
not
you
present.
agree
These
with
are
it or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they
Okay,
will not
guys,
be
look at the
resolved
bailiff
to your
behind him,
satisfaction.
and then
It's not about my
tell me this
satisfaction.
isn't the
It's about
bailiff
the
right here.
Constitution. It's about what's right.
That's
going
exactly the.
Are you going to
Follow the
answer
court's
questions as a public servant on why you're making up laws that are not
Seriously, look at the top right corner and look at the bailiff.
Illinois versus Allen and never utilized the mute button. It never said anything about a mute button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
He didn't make it.
that not-
closing argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You
closing
can't invite me
argument.
back.
Well
over.
done,
I
Lindsey
can
Broussard
say
over on
my rights.
YouTube. You called it.
So how can you
He didn't
invite
make
me
it.
to do
The
anything?
courtroom is
He didn't
continued
make
so
it.
that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me.
There will be probably
So now
a case
now
study.
you're trampling over my first.
You guys, this is probably going to move into a case study, which is going to be Brooks versus or state of Wisconsin versus Darrell Brooks. I don't doubt that that this will come up in some type of case study. While they're doing that, you guys, why don't we finish Darrell Brooks's opening statement here? I know we made it through. We made it through a couple minutes of that. Okay, I'll pick us right back up where we were at. So if it starts giving me buffering issues, though, I'm gonna have to close that out because I know that all the servers are jammed up right now because it is a big deal. So share the stream out, you guys, if you would please. Let's get as many people in here as possible so they can all experience the finality, if you will, of what is Darrell Brooks. So, but we're gonna go ahead and present this one here. So this is Darrell Brooks is being kicked out. He's being put in his fort room right now. And let's do this here. Get this out the way, and then this is the second half of Darrell Brooks's opening statements, as opposed to his closing arguments here.
A lot of suffering involved in this incident. A lot. Obviously, with the families, with the community, and even the alleged defendant's family as well. There's been a lot of suffering. A lot of misunderstanding. And I just want you to keep in mind everything that will be presented in its totality. Keep in mind.
Remember, they're not back in session yet, guys. They're moving Darrell Brooks over to his fort room. So
the power that you have. I believe that should escape your knowledge. This has been a long process for everybody.
Pause it right there. You guys, I know that it's people are nervous. We're gonna miss the opening statement or closing argument here. So what we're gonna do is I'm gonna give you guys a side by side here, so there won't be any confusion. So we're gonna do this right here, and the one on the left is where court's at right now. The one on the right is his opening statement. So we're good. Court's on the left. Live court's on the left. Darrell Brooks opening statement on the right.
When it's time for you to make your decision, all of you, I believe that, and I pray that it's the right decision. That all the factors are weighed.
So he's not back in court yet. He's over in his special little fort room, but they haven't started yet. There's no audio yet.
There's been a lot of words thrown out there about the alleged.
About the alleged. You're not alleged. You are, without a doubt, the guy. So he's over here. This is over here. Darrell Brooks is, he's talking. There's no audio set up in the courtroom yet. So we've got. Let's do this for you guys. So yeah, nothing's happening in the courtroom yet. Yeah, this is live over here.
A lot of speculation, a lot of ridicule. Words like demon. Words like monster.
Mm-hmm.
I know a lot of the time I've been before you see me with this mask on. Yeah, I've had my reasons for that. But I feel now is the time to, it's important that you see me for who I am. No mask, for who I am. think this is the moment for that.
There's no audio, just so you guys know. Keep that clear on the left. There's no audio yet. And thank you, Paris, for those stars. Fort Brooks, yeah. Yeah.
I pray that your eyes and ears remain as open as possible.
Because I'm going to kill your brain. Just going to annihilate your brain. Your frontal lobe is going to explode watching this trial. Yeah, he's mad he doesn't have his boxes to build his fort.
I understand that you alone decide this case, this matter.
You guys, the video on the right is was his opening
in
statement.
Your hands. All of you. To determine for yourselves what truth is.
We are back on the record.
So you got to determine what truth is.
Appearances are as they were before, except that Mr. Brooks has been.
So we're going to go straight into
was brought to the main courtroom. And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute, but those rights do not come in a vacuum when we are in a court proceeding in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument, but he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle. And she is still present with it, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them. And I
What up,
expect
Skinny
that he
Jeans
will not
Media?
interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function.
How long is he going to be back?
If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling
What do you think?
accordingly.
I feel like there might be a little bit of echo or
Quick things, please could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head, they've done that, thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability, so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable? They can see it. All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram is probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them.
I don't know how long the prosecution plans on going for their closing arguments, but I wouldn't imagine it's.
Then are you turning off the PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good. Thank you.
All right. With that, the jury is to be brought out.
How long will he last? How long will he last?
Okay.
You already know he's going to be firing off some daggers at the judge. Just waiting for it. Then he goes to his, and then here we are. This is him right now over in his box, his his fort room, which is his box court. It's not a box fort; it's a box court in his his fort room. Oh man, it's too much. It's too much.
All right,
I can't help
jury,
but laugh.
please. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you at the very beginning of this case was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And clerk, if you'll please turn on the PowerPoint. Yes.
Oh, hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom, you know.
Share the stream.
All week or the last
Here we
3
go.
weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you, I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Here we go.
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
How are they able to object to
Your
closing
objection's
arguments?
noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Doro. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa, whoa, whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77.
Sorry, not sorry. I
Mischaracterization
have
of
76
Yes,
charges, not
correct.
77.
Sustained, it should be count 68 through 73, I believe, and then
Get it
74
right.
through 75, and then 76.
Yeah.
Thank you, Your Honor.
Could have changed the whole case.
I apologize for my math skills.
We all make
68 through
mistakes.
73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Doro. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorenson. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulich. Count 5, Bill Hospel. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The extreme dance team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the extreme dance team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt, there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Hopper, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not.
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning. Remember, our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Hopper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how can,
Hopper.
so how can speculation be made to what was saw? If
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Hopper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanners back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's intentional.
Mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route. We'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please.
Graphic. I appreciate you guys sharing the stream as well.
That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we going to mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulich square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup, they were struck by the red SUV driven by Darrell Brooks, keeps going, plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play.
I'm not going to have that played. I can't have that played on the stream. So
keep watching the left side of your screen. That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they're supposed to think?
Proper argument, your objection is noted, it's overruled.
I would argue that it's, I would say that it's improper, and I move
Mr.
for a
Brooks, I made
mistrial.
my ruling, I'm going to mute you if you don't follow the rules.
Exhibit
for a
1.
mistrial.
Exhibit 152. Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from State's Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me.
Sorry about the mute, guys. My bad.
So, State's Exhibit number 130. Put that up here quickly. Thank you.
And I just hit an 8-hour timeout. That's
whole
all.
thing,
So
folks.
I'll be out for 10 seconds at
Suffice it to
4:30.
say,
Come right back in.
After Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there.
Not yet. It's the DA's for
So-
the state right now. Then Darrell.
Some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name, and I don't know who that is, and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas Parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Depends on your definition of the third.
Tone that back, because if that was me, if I would have
Well,
said something like
you'll have your
Objection
opportunity.
is
So,
noted.
you know,
It's overruled. These are closing arguments.
it's
There's nothing improper. It's noted. It's
wanted to-
overruled. She may
I
continue.
just wanted to be fair.
You'll have
Your
an
Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal.
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks. And I apologize.
It's together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulich, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence. Use the map. 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please.
Again, I am not permitted to show anything it's excessively violent. So if that happens, it looks like it's about to happen, I might have to
Go ahead.
Oh man. Overlay the video. So I apologize. But I doubt they're going to be able to show it anyway if it gets excessive. So no video, no sound, so you're good. Okay, that's good. Well, yeah. And that mother's testimony the other day was heartbreaking. I'm sure there's family in the crowd. There's got to be people that are there that are yeah. I was going to cut. We're a little bit on this film, just a little bit behind the next one, but the video they're watching, so you guys know, is a stitched together montage of everything that happened at the parade.
Thank you. Before we continue with Mr. Brooks's closing arguments. I'm going to take a short break. All rise for the jury, please.
Am I muted?
No.
The jury should know that they can nullify.
You are muted now.
Yeah. Sorry. She told him already, if you bring that up, you're going to get kicked out. So
Be in recess for about 10 minutes.
I don't think that his closing arguments are going to take 40 minutes. I hope they don't. But we are in closing arguments, so that's happening right now. We got about 10 minutes of Darrell Brooks. He's over in his box fort right now, doing what Darrell Brooks does best, which is being a nuisance and just a raging hemorrhoid when it comes to his everything about him, actually. Let's see if we can't, well, we have a 10-minute break here. Let me pull something up for you guys. All right. Okay. Yeah. So this is the tail end. I'll give you guys the tail end of. I'm hoping that his final arguments don't go, because I need to clip out. I hit an 8-hour window where I have to, after 8 hours of stream time, I have to. It drops off the Facebook feeds. So if you are on Facebook right now, I'm going to go ahead and clip this out right now. So I'm gonna close the feed down, and I'm going to reopen it in about 20 seconds. I believe that's the best way for me to do this, so that I can make sure that there is no possibility that we get cut off in the middle of what he's saying. I definitely don't want that to happen. And it might be a good place for, just as far as a break goes, so we can, this is part 2 of day 14 of the Darrell Brooks mass murder trial here. And yeah. So if you're on Facebook right now, it's not complicated. You guys it's not a big deal. All you have to do is make sure to just refresh this in 15, 20 seconds, and we'll be right back up for part 2 of Darrell Brooks trial, day 14. So if you're on YouTube, same thing, refresh. You guys, I know we've got like 400 people in here right now. Come back in. I hate doing it, but it's better to do it now than when he's in the middle of what I'm sure will be whatever he's going to do for his final argument. So if it's anything like his opening statement, we'll see what closing arguments look like. So sit tight. I'll be back in just a moment. All right.